Thank you very much. I'd like to bring this month's meeting of the Metro Historic Commission to order. First, let's get the adoption of the agenda updates from Robin.
Okay, what we have is 1239 6th Avenue. It's been removed from consent and will be under new business. 300 Broadway, you'll see that on your agenda twice. One was for signage and one was for lighting. Both of those have been deferred. 114 Windsor Drive was deferred at the request of the applicant. 123rd Avenue South has been removed at the request of the applicant. Not sure if that one's coming back to you or not. And then outbuildings and revisions to rules of order and procedure have all been deferred.
All right, thank you very much. Any more questions? Any questions about that from the commissioners about the agenda? Okay, first, are there any council people here that would like to speak before we start the meetings? Seeing none, do I have a motion to approve last month's meeting minutes?
Motion to approve.
Second.
All in favor?
Aye.
All opposed? Okay, motion carries. So as we start the cases, for each case there will be a public hearing. We ask that the applicant keep their presentation to under 10 minutes, which means 8 minutes, and then you save 2 minutes for later. We will have, Sean, are you the timekeeper? Paul is the timekeeper, so Paul will let you know if and there you also have the big sign there too. We ask that the public keep their comments to 2 minutes unless they're representing an organization or group, and they may have 5 minutes to make sure that when you come before that you make sure you state that. Appeals before the decision. Pursuant to the provision of Section 2.68.030 of the Metropolitan Codes of Laws, notice is hereby given that a final hearing before this commission is appealable to the Chancery Court of Davidson County or the Circuit Court of Davidson County via statutory writ of certiorari. You're advised to seek your own independent legal counsel to ensure that our appeal is filed, that your appeal is filed in a timely manner and that all procedure requirements are met. You should also seek independent legal advice regarding the applicability of the writ of certiorari to the specific decision of the Historic Zoning Commission. The next thing up is the consent agenda. Items on the consent agenda will be voted on at a single time. No individual public hearing will be held, nor will the commission debate these items unless a member of the audience or the commission requests that the item be removed from the consent agenda.
Good afternoon. This month's consent agenda includes 104 5th Avenue South, an application for signage, 602 McFerrin Avenue, an addition, 1103 McKinney Avenue, an addition, an outbuilding, dadu with setback determination, 1611 Fatherland Street, an outbuilding and setback determination, 2034 10th Avenue South, an addition, an outbuilding, a dadu, 2105 9th Avenue South, an addition, 1608 16th Avenue South, an addition and setback determination, 2006 White Avenue, an outbuilding, detached accessory dwelling unit, 1504 Paris Avenue, an addition and detached accessory dwelling unit and setback determination, 2509 Belmont Boulevard, an outbuilding, detached accessory dwelling unit with setback determination, 3633 Richland Avenue, new construction, infill and outbuilding also with a setback determination, and 4412 Elkins Avenue, an addition and outbuilding also with a setback determination. Staff has reviewed these projects, have determined that they meet their respective design guidelines, and recommends approval of the items on the consent agenda.
Okay, thanks, Paul. Any questions to Paul regarding any item on the consent agenda? Okay, thanks. Open public hearing. Anyone have any statement about any of the items on the consent agenda? Okay, seeing none, close public hearing. Do you have a motion to approve?
I move approval of consent agenda.
Second.
Okay, we have a motion and a second. All in favor?
Aye.
All opposed? Okay, motion carries. Robin, do we have overlay recommendations? Or is that one?
Not this month, no.
Okay, thank you. Okay, so first is previously deferred items, 532nd Avenue South.
(532nd 32nd Avenue South is located at the corner of 32nd Avenue South and Blakemore. In January 2016, the Historic Zoning Commission reviewed and approved infill and construction on this lot. An MHDC inspection in late January 2017 revealed that the siding reveal and the foundation material were not installed as per the approved plans. This application has retained the materials installed in violation of the approved permit for the infill construction. The applicant installed the lap siding to have a reveal of approximately 7 inches. The design guidelines state that, quote, "Cement fiberboard siding, when used for lapped siding, should be smooth and not stamped or embossed and have a maximum reveal of 5 inches." The preservation permit for the project included drawings submitted by the applicant that showed lap siding that measures as 5 inches. In addition, the preservation permit has text added by the MHCC staff noting that all siding reveal must be 5 inches or less. Both the text and the drawings that are part of the preservation permit contain language that states that if changes are made during construction, the applicant must seek approval from MHCC staff. The design guidelines require siding to have a maximum reveal of 5 inches because historically, siding was typically had a narrower reveal. Although there are some instances where historic structures have a wider reveal, the more typical historic siding reveal is less than 5 inches. Even on outbuildings, MHCC has required that siding have a maximum reveal of 5 inches. Up until approximately 1950, lap siding in Nashville generally had a narrow reveal between 3 and 5 inches. Some forms of wider reveals, approximately 6 to 8 inches, can be found, but they often have mitered corners. Pressboard, masonite is probably the best way to think of it. Pressboard siding, although available much earlier, did not take off as a siding material until the 1950s. This type of siding often had wider reveals because between 8 and 10 inches. Because the historic context of this neighborhood is primarily buildings constructed prior to 1950, and because the wide reveal with corner boards is generally associated with later time periods than the period of significance for this neighborhood, staff finds that the narrow reveal with the corner boards to be more appropriate than the wider reveal installed in violation of the permit. Staff recommends that the siding reveal be changed to be a maximum of 5 inches. So that was the first issue. The second issue is the foundation material. The drawings for the preservation permit show a brick foundation. Instead of brick, the applicant used a cut veneer limestone for the foundation material. As stone was used historically for foundations and is typically approved by MHCC for foundations, the staff finds that the stone is appropriate. However, the foundation line and the placement of the infill was changed during construction. On the front facade, which you can see here, facing 32nd Avenue, the approved drawings show a consistent foundation line extending from the porch over across the facade. However, as constructed, the foundation line to the right of the porch is lower. Staff recommends that the foundation line be raised to the right of the porch to provide a consistent line. This is the Blakemore Avenue facade. The approved Blakemore side facade drawings show that the foundation line steps up after the porch for a 2-story bay and then steps back down. This stepping of the foundation helps to decrease the perceived height of the structure, specifically the projecting bay. The site slopes significantly towards the back, making this area highly visible. However, as constructed, the foundation height is lower, which increases the perceived height and scale of the infill. Staff recommends that the applicant bring the foundation line up and step it to be more in keeping with approved plans. And then again, here's the rear facade, which is highly visible because this is a corner lot. The project did include an attached garage, which we approved because it was located at the basement level. The approved drawing showed the foundation materials continues around the rear of the building and extends up around the garage doors. However, as constructed, the foundation material at the rear is only 18 to 24 inches above the ground. The siding on this facade extends down nearly to the ground, which increases the perceived height of the rear facade. Because attached garages are only approved at the basement level, it is important for the garage doors to be surrounded by a foundation material. In addition, stopping the stone at the rear corner with a corner board is like a giveaway that the stone is a thin veneer versus a regular actual stone piece. The purpose of continuing the stone fully around the building creates the illusion of a full stone foundation. The foundation line changed during construction and so no longer matches the elevations. Therefore, staff recommends that the stone veneer be stepped down to just below the rear awning and continue around the line of the back of the building, which will help keep it just above the garage doors as originally designed. So in conclusion, staff recommends that the following changes be made to the infill construction. 1, that the siding reveal be a maximum of 5 inches, and 2, that the foundation line continue in a similar fashion as permitted and follow the line illustrated in Figure 8. And I guess Figure 8 is in your staff recommendation, but it's is similar to what the illustrations show here. I believe the applicant is here, if you have questions.
Okay, thank you. Any questions for Melissa or staff at this point? Okay, thank you. Would the applicant like to come forward and please state your name and address?
Mr. Chairman, members of the commission and staff, my name is Bill Purcell, and I'm the attorney for the applicant. I live at 1414 Stratton Avenue in East Nashville, and it's a privilege and an honor to make this my first appearance before this Metro Historic Zoning Commission and say two things quickly in the interest of time. No one appreciates the work of this commission more than I do. No one supports this zoning or these guidelines or the independence of this commission more than I do. And I think at least one member of this commission knows, lived the majority of my adult life in a neighborhood that's protected by this commission, and it is my intention to remain under the protection of this commission for the remainder of my life, however long that may be. With the help and support of this commission, Jonathan and Karen Harris have built their home there at 532nd Avenue South at the corner of Blakemore, and their son, Braven, just stepped out for a moment, but he'll be right back as well. Mr. Harris will ask to speak to you in just a moment and explain to you how he hopes to occupy his new home and how we got to this point. I've undertaken to represent them for two purposes. One issue that was actually quite simple and I believe actually compromised in the moments before the commission convened, although staff was not fully aware of that. As to the foundation, you will find from pictures that you'll be given by Mr. Harris that most all of the lines have in fact been increased since the staff report in March, which is the one that is before you. You'll see photographs of that. As to the garage area, I believe there's an acceptable compromise, and I hope that it's acceptable to the commission as well, to draw the line basically not quite as high there on the side of the garage as you see, but rather take the sight line of the higher wall that you see there toward the back and run it directly across and all the way around, joining the other stone on the other side, so as to limit the plane, if you will, of that back extension of the house, continuing the foundational elements all the way across, but at the same time minimizing the effect on those other additions which you see above the garage. I believe that that's a compromise that I believe meets all of the needs of the commission. The more important reason, and the reason truly I took this case, is as strongly as we do in fact support the work and of all here, is because the violation that is created, the primary violation in this case, is from a regulation that we believe is wrong in this case. It is one particular guideline. It is one particular, and we would argue small, in a rather large panoply of guidelines, but we believe it is wrong, and we believe only this commission can deal with that. When we are looking at the guidelines regarding new construction and addition, we know, and I think you know, there's a very specific provision dealing with materials where new construction is involved. We would say, on the face of it, this guideline, though frankly I had not seen this before, is now to me quite clearly arbitrary on its face. As the staff explained it, I think it is in fact the way the rules read. It allows for a reveal of 5 inches only for cement fiberboard, period. 5 inches, that's it. However, there is no such restriction within that rule upon any other material that's allowed under the code. Wood would be allowed at any reveal whatsoever. In fact, masonite appears also to be permissible at any level, not with or without the mitered corners that are described. A mitered corner is within that rule, but it is all under the subtext of fiberboard. So first, and perhaps foremost, as you look at these rules, not just in the context of this case, but in all the others, because this particular rule is tracked, this section of this rule is tracked in every single area of the city. It appears to begin in the Edgefield area. It appears to be applied then in Lockland Springs. It moves its way across the city, this specific provision with these words, until one moment in time, in very recent time, when this staff and this commission realized, as you considered Inglewood, that this needed to change. And indeed, you changed the rule as it applies in the Inglewood Conservation Zoning Area. In that particular conservation zoning area, you made a very different requirement. You said, and you're very clear about this, you allow a reveal of 5 to 10 inches, depending upon context, allowing the staff then to look at that neighborhood, which in my opinion, and I think and believe as you consider it will be the opinion of this commission as well, in that Inglewood neighborhood, much more similar to this extension of this particular neighborhood, which is, as you know, this was an addition that was added very recently to an existing conservation overlay. All the data that Mr. Harris presents will make clear the extension of this conservation zoning in 2014 did not take into account the conditions in his neighborhood, and frankly did not take into account what this commission has subsequently determined was a more modern regulatory scheme that should, we believe, be applied in this case as well. And with the permission of the commission, I'll now ask to recognize Mr. Harris.
I bought this house back in 2006. It was a brick ranch house. It was in really rough shape. I bought it from a guy that had a yard sale. And I lived in Old Hickory at the time, and my dream was to move to Nashville. And so being from Old Hickory, I had bought a number of homes in the historical community of the Old Hickory Village. And I had 8 homes that I had put on the National Historical Registry. At the time, I don't believe the Historical Commission was over that community, but I took great pride in renovating those houses right out of college and putting them back to their original state. So from my beginnings in real estate, I had a desire to stay consistent with neighborhoods. When I purchased this house, the house was not conforming to the neighborhood. When I purchased the house, I was barely able to make the rent payments, and I had a bunch of Vanderbilt fraternity kids in there, and the neighbors hated that house. And so I always had in my mind, one day I want to build my house and I want to move to Nashville. And so fortunately, there came a point in time where I was able to do that. And so whenever we decided to tear the house down to move there, you'll see that this is my first building permit that I've ever pulled on a house. So this is my primary residence. And so I am a bit naive and a bit of a rookie at this in terms of knowing how to go back and research the guidelines. I was so stupid that I didn't even know that to tell my architect that I was in a historical community. So we drew up the plans, I turned them in, and it was immediately rejected a number of times. And my architect said, "You should have told me." I said, "Man, I didn't know." Finally, we were approved. And so I remember I got my permitting. The very top thing, they said, make sure you put this on the outside of the house to be able to show that you have your permit, which I did. The rest of the papers, I didn't really pay attention to those. So that being said, I kind of found myself in a position to where I did not know that I was had an infraction of 5 inches. That being said, whenever it was asked upon me, what exterior structure do you want to put up? I said, well, the plans here show that it's hardy board. And I said, so I got to do hardy board. It did not, on the specific plans that my architect submitted that were approved, did not have a dimensional size. It just said hardy board. And I said, you know, looking at my neighbors to the right, looking at my neighbors to the left, I said, let's just match our neighbors because I want to stay consistent. And so the Historical Commission was right whenever they said that what was approved was brick on the base of the home, and I went back with limestone. The reason why I did that is because I looked at my neighbors and I said, you know what, I want to stay consistent with them, and I want to make sure that I spend more money to stay consistent. And so my efforts from day one was to look like my neighbors. That's where the 7 inches came from. It was not an effort to go against some sort of ruling. It was, I looked to both of my neighbors from side to side. If you look at the first page, it shows on 532nd Avenue, the neighboring homes. These were 2 historically contributing homes that I looked to, and that's where I drew my conclusion of 7 inches. On the following page, you'll see a map of the historical overlay boundary. I drove the streets and I began to make notes of homes that have 7 inches or more. When I originally said that I had bought and sold houses earlier in my career when I had flipped homes, I don't do that anymore, in Old Hickory Village, I was familiar with asbestos siding. And so I remember that that's more than 7 inches. There are a number of houses in Hillsborough Village that had asbestos siding from a previous time. So that being said, I marked every lot that I was able to find, and on the following page, I wrote down each address to associate where it was on the map, and there was 179 homes that I was able to notate that had a minimum of 7 inches or more. On the following page are some examples of plenty of homes that I've seen around the community that had 7-inch siding. On the pages after that, there's homes, I think I put 10 examples of homes that were built in 2013 and 14 where I have measured that they were 7 inches or larger. And so I talked to a number of the people who had built these homes, and they said, you know, whenever the rules had changed, we went ahead and started building houses prior to the rules changed. And so that's how they were able to get these approved in 2014, whereas in 2017, I'm no longer approved. And so I just put these examples of houses. So I'll let you know that my intention was pure. My efforts were not to cut corners. I really wanted to match the houses that were on each side of me. That's what I also did with the rock. We've made the adjustments to the staff's recommendation for the rock. I have recently moved my company on 30th Avenue, and so I'm 2 blocks away, so I've been looking forward to being able to walk to work. My goal is to move into the house as soon as possible. The reason why I have not torn the 7 inches off is really there's a cost prohibitiveness. My loan is just not enough to cover it, and I've spent about $75,000 extra on the house that was not approved that I've come out of pocket. And so there has to come a point to where I've just not been able to continue on this. So I'll end my time with 15 minutes to go to say I appreciate you guys. I understand what you're trying to accomplish, and I want to work with you on this.
Okay, thank you. Open public hearing. Would anyone like to speak regarding this project? Seeing none, you don't have to, since you went over, do you want another minute for rebuttal or anything? Since I don't know if you finished all of your thoughts there, or?
We could have just one moment.
Okay,
Yeah.
I'll just put 1 minute on for
Mr. Chairman, thank you very much. We would ask, under these facts and circumstances, that you approve the compromise that we believe that we reached regarding the foundation, which we think is fully consistent with this commission's goals. Secondly, as to the major violation, the one that was described here, we would ask that you find no violation under the facts and circumstances of this case. But if you are unable to do that, we'd ask one more thing, and perhaps somewhat unique, because of the finding regarding the rule itself and the changes that have occurred in the regulatory structure of the city since the time this rule was promulgated. We'd ask you to defer your final decision and allow the staff to take time to talk to the council member, Berkeley Allen, for that area, who is not here in opposition today, and I think could be talked to regarding the application both of that rule and the more recent rules. Also, the opinion of neighborhoods, which I trust and believe Councilman Allen knows the most about. And also to take further time to consider whether or not in the extension of this particular conservation zoning, and that's what's occurred on at least 2 occasions. It was extended. If during that extension, in fact, the circumstances of this neighborhood were taken into account, we believe when you do that, you will find that this rule, at least as it applies in this section, should track the Inglewood rule, and that there would be the opportunity for conformity, not only with what this commission is trying to achieve, but with the needs of the neighborhood overall. Thank you very much.
Okay. Thank you, Mayor. Okay, public hearing is closed. Open discussion. I guess I'll kick it off just until you guys get your thoughts going. So they brought up some of the other areas. Maybe we can talk specifically about the areas that were changed to a higher, why that was a different than what we have approved for this conservation area.
Let me start by saying the 5-inch reveal on Hardiplank siding, that smooth face, that's a policy that the commission's had in place even before I started to work for the commission, and I've been here 20 and a half years. So that started as a way when you were looking at newer materials for additions and new constructions. Things like masonite came to the commission, that was disapproved. Hardiplank was a new material 25 plus years ago, and so it's something you guys agreed would be appropriate, but only with the 5-inch reveal. At that point, we only had a few districts. They were early districts. Since then, as each district came online, we did look at that historic context, and I was historic zoning administrator when Hillsborough West End went into place and Elmington Place. Obviously, it's been expanded since I was historic zoning administrator, but we did look at that and we found that to be compatible. That said, you do take each case on a case-by-case, single basis when you review it. And there are times when people have come to you and made the case for using a wider siding as a secondary material, and you have approved that on many occasions over the last decade. You've also approved a wider siding when someone was making an addition to a historic house that had a wider historic siding. And so those are the times where you've deviated from that. That has been policy, again, for over 20 years. I'm not sure at what point it got added, not as a guideline, but as an italicized portion of the guideline that gave reference to people doing work. But at some point that was added. But again, it's been a policy for over 20 years. So does that answer your question, Brian?
Yeah, that was the kind of historical perspective I was looking for. Anybody want to jump in with
I do have another question for staff. Mr. Purcell in his presentation, as I understood it, said, question the legality of this. Can the staff from AC address the legality of what our regulations are?
Do you want
So I think Tim touched on this in that the part that addresses the siding reveal is in the italicized portion of the guidelines. And so while it's not binding per se, it's what we encourage the board to follow, it's what we encourage applicants to follow, and that's sort of our guiding point. Does that answer your question?
I have one more question about the foundation line. These appear to be after what have you guys reviewed this at all? And can you?
Yes, we had a discussion this morning and then a clarification right before the presentation, so I apologize I didn't have an opportunity to tell Ms. Baldock about it. But if you look at the picture that's up there right now and you look towards the back of the garage door, there is a retaining wall down the interior lot line. And so their proposal is to carry the stone up to that same height across the back of the building. And we agreed that that would be appropriate and meet the original intent of what you approved, if not exactly the same line.
What about the higher side on the, I'm not sure that.
And that would remain.
So, okay.
So just right now, what you don't see is that bay has a higher stone. The stone goes up higher, so it steps down there. And so right there at that corner where it stops in this photo, you'd have another step down, but then it would carry on across.
Okay.
So make sure I'm clear on that. We're coming across the front of the doors that'll match the existing or the installed retaining wall, which is about 2/3 up on the height of the garage door. It'll turn the corner heading towards the man door, person door going into the basement or garage.
That's great.
And then it jumps at the corner.
That's great.
I might offer, given that there's several retaining walls that are some existing, some new on the site, the solution sort of falls apart whenever you have this really thin corner detail. I think for resolution and keeping in mind the complexity of taking off an awning and siding and all those things, if there were, I might suggest if there was some extension, and even you'll often see on a historic house, it'll come out further and then dive down. That way that, that we don't have a tremendous amount of additional stonework, but that it's believable architecturally that the stone is a wrap around and a base for the house, so that we don't have a condition that you just wouldn't see with a stone foundation, which is the siding would sort of come up and there'd be this reveal of, oh, that's 3/4 of an inch
So
thick.
if I understand you correctly, where the stone is in this picture, you're recommending remove that corner board and carry the stone around the corner just a little bit so it appears to have.
I think that offers some constructability problems. My suggestion would be just to have a little wing wall, even as little as 16 inches, so that you can come around, wrap the corner, and then it comes down. I feel like with the skill that is exhibited in the photographs, that the mason could accomplish that, and it would resolve what would. You've gone a lot of trouble to wrap the foundation in stone, and it just falls apart sort of right there at that corner. And I think in the grand scheme of admittedly additional dollars spoken that are spent to accomplish this, that would be not a tremendous ask of the applicant, and I think would resolve architecturally what we're trying to do, which is the believability of the material.
What I recommend is right now the second condition is different than what we've been talking about. So I would just recommend a change to that second condition. If we get to that point, everyone agrees that wing wall just be added there, and that stone wall, or the stone at the back comes up to meet the retaining wall.
Okay, and when we get to that point, we can craft the motion to take care of that. So the big thing is the siding, obviously. Did you have something, Aaron?
I wanted to make sure I understood. With what Ben just described, staff would recommend that as a compatible solution for the stone portion. Okay, great. I had a question on the siding. the period of significance, sounds like that's important, and that was the reasoning for, if I'm understanding correctly, the reasoning why it's a little different in Inglewood. How does the period of significance for Inglewood compare to this particular portion of Hillsborough West End?
For us, we didn't, the period of significance is part of it, but we really looked at just what's existing, the historic properties that are existing. And you have, it's just a very different neighborhood beyond just the period of significance. Inglewood Circle, the majority of the Inglewood neighborhood is all masonry, brick, stone, and stucco. And there's only 65% of it is masonry, and there was just one street, Inglewood Circle North, which is a little bit later, has 1950s construction and has all lap siding. So that was really sort of the reasoning behind that language for Inglewood. We didn't really see Inglewood as being similar to this neighborhood. The immediate context around this particular lot is 1920s and 1930s, where typically you did see that narrower reveal.
I'll just add that the period of significance is earlier for this neighborhood than Inglewood. Obviously, in any neighborhood, it's not purely developed at the same time. Many pockets are developed later, even in our earliest neighborhoods where a larger property might have been subdivided later. So you don't have a pure period when everything was constructed, but generally the Hillsborough West End is earlier than the Inglewood neighborhood, and that was why we had that difference related to siding.
Okay. And then I guess a follow-up question from Robin's explanation about period of significance versus context, and them both being important. But the context, the examples that the applicant gave of other homes with the 7-inch reveal, those were built before the extension of the overlay? Is that right?
This is our first time to see that map, so I don't know. Some of those may have been constructed prior. Some of them may have replaced siding, and it's not historic siding, even though it may be a historic building, so I don't know.
Okay.
I mean,
because it's also not smooth, so it doesn't look like something we would have ever approved. Okay.
We certainly would have never approved it, so it's either something we didn't get to review, predated it, or it's in violation.
Let me go back real quick on how we got here. So the architect that the applicant was working with, I guess the drawings, either according to him, it did not show the 5-inch, but I guess in our write-up to them, we indicated the 5-inch. Maybe just make sure we can get that part on the record.
it is drawn as 5 inches, so we took that to mean that that was the request, and it was included on the drawings are included as part of the permit, and we added notes as well.
Okay. That's why, I mean, and, we always feel for the applicant when they put that much work and extra effort into it, but we can only, enforce what we have, and when the information is there, it's kind of a little bit more difficult to, when we've made it 5 inches and I guess brought on an architect professional, but yeah, I'll wait to hear more of everybody else's comments about it.
We see this a lot, typically when the wrong material is put on in violation of what the drawings were and what the conditions were of the approval. And as far as my history on this board, I don't remember us reversing that decision very often, if any, unless extraordinary circumstances were there. The applicant asked for deferral if we weren't able to agree with this. One of the things that they do have in their exhibit is a listing that claims a number of houses within that area have 7-inch siding or greater. I think it might be appropriate to defer and then ask the staff to review that, see if this is a different condition than what we've been dealing with in the past, or if it is or if the historic typical was for the smaller margin siding. So.
Before we go down the deferral road, which we might end up doing, is there any other comments? Because only thing like you said, it is something that we've done for a long time, the 5 inches. We just had to be careful. My precedent police is who I was waiting to speak up, but we have to be careful with this. There have been several cases for 20 years that we've made them do 5 inches. So I just, want to make sure we talk through that a little bit before we go. Not saying we shouldn't, but just want to talk
If we're
through
setting ourselves up to change that and make it an official, even though it's an italicized, but we've stuck with that, with the smooth 5-inch, I think we need to make some changes to make sure that if the policy changes, if we change our opinion, our designations, that we need to change the policies. And we set precedents when we make these exceptions.
And there's always the opportunity to look at guidelines and make revisions to that, to policy. Our concern is that that's a fairly big study to look at all of the buildings within the district and determine what those siding reveals are, and that is not something that, quite frankly, we have the money or the time to do. It's not something that's going to happen in a month. And right now, we're dealing with a violation. So we recommend, rather than changing the rules in the middle, that be a consideration, something that we look at, but not try to rush that to be done in 30 days, because quite frankly, we're not going to be able to.
I just, I feel for the homeowners simply because, the plans were permitted as they were, and, we expect the professionals to follow that. And as I read through there, we also make, even though they didn't show a dimension, that we made notes on the plans before they were permitted that the 5-inch was the acceptable.
We did, but it is drawn as 5 inches.
I realize that, but
so again, that is.
I thought that they had said that it was drawn as 5-inch, but not actually specified as a dimension, but that we actually added as they were approved.
Yes.
The 5 inches.
I think the one other comment that I have is that driving past this house and looking at the other houses on the street, it looked to me like every house, if not every house, then almost every house on Blakemore is either stone or brick. And that although there is some siding that's present, it's on the upper story and it's a minor place. This is the only house on Blakemore, that section of Blakemore, that's all siding. So it's highly visible and different than the other houses that are there. So.
Drafting a motion to accept this as submitted today, we need to make sure that we have covered ourselves such that this is an exception, not necessarily the rule, and then we're not setting this as a precedent or something to be used as a guideline. We need to be careful when we do that.
Well, and I think the problem where I was strict, and like I said, I'm definitely sympathetic because there's been a lot of resources put to it, is that it is a violation. I mean, if it was brought to us beforehand and then the argument was made, we would be sitting at a different point. We could say, but this, what else can we do but put it on our drawings? And so anyway, I want to hear any more kind of conversation about that, but we just have to be careful in the violation standpoint. If somebody brings it to us, I think we definitely want to vet it maybe potentially differently. But
I think the 5-inch reveal, that standard, is something that's very well established. And I know since I've been on the commission, there's been several people who have been in violation of that. A few I can remember off the top of my head, and they had to take it off and redo it. And it was a very similar set of circumstances. It was either shown drawn as 5 inches, dimensioned as 5 inches, or there was a condition or something in the permit that made it clear it was limited to 5 inches. I don't see, unfortunately, anything here that is remarkably different than those other cases. And I think it'd be very arbitrary to make an exception here when we didn't before. And it's certainly not something we would approve if it was in front of us on first impression. If they can show that somehow the contributing homes in this neighborhood historically had much larger reveals, or not much larger, but it's 7 inches or more. If there's a number of those, I think that would potentially change the outcome. But I don't think we have that. We've got a list of properties in the applicant's package, but we don't know which are contributing, and we don't know if that siding's original or not. It's going to be hard to, I think Robin has a point, it's going to be very hard to figure that out.
Yeah. Aaron, let me ask you a question of staff. When we did the surveys of the neighborhoods to establish the guidelines and their designations and the appropriateness of those designations, don't we have a list? We have a list of those contributing structures so that we might, even though we can't do it, we might provide it to the homeowner so that they might do that.
Sure, the issue is the siding. The building may be contributing in historic, but it may not have its original siding. So it may be a historic building with a wide reveal, but it's not necessarily, it could be a masonite or something, or anything that was added later. So I think that what we would need to do is have an architectural historian do the survey, because they understand the history of the buildings, they know the forms, and they will be able to tell by looking at it whether or not that's probably original material or not, based on the form and style of the house.
I mean, and I know we don't have time to do, you all don't have time to do that, but I mean, at least that's a way of maybe getting some more information that might support the motion.
Give me 1 second, Mayor. Just let us debate this. Talk just about a little bit more. If there's something you want to whisper to Tim, you can. But let us keep
Thank you,
talking.
Chairman. I was just going to respond to the inquiry.
Oh, that's okay. Yeah, just whisper to Tim. Do you? Were you about to say something, Ben, or were you just looking? Okay. It's just a lot of work. I mean, this is anyway. I don't know. Were you about to say something, Caitlin, or?
You know, I agree with Cyril, you know, that especially since all the surrounding homes are all stone and brick and things like that. So this is very noticeable already, being siding. You know, it's very clear that it's approved at 5 inches. You know, we get cases all the time, even if the intentions were good, and they, you know, I realize that the homeowner, and respect that they've done a lot of work on this. You know, that if you want 7 inch, you know, you could just, if you wanted to, you know, if we keep make exceptions, it's just, you know, kind of do it, and then they'll make an exception. You know, not that this is what's happening here, but people will do that. Yeah. So that's scared about the precedent setting that, you know, that we have to kind of deal with sometimes. So that's my thoughts.
I think the other thing, too, is we don't always know what the homeowner and their architect or their contractor had their agreements. So it's where is that miscommunique of the architect drawings versus what was actually put on. So, you know, we've not discussed that, but that's what could also be in question, is we don't have control over that, is how the owner and their contractor have, you know.
Sort of where the decision was made, by whom to make that change, or where the misunderstanding came in reading the plans.
Right.
Well, does anyone want to craft a motion, and we can kind of see how it goes?
From what I've heard, I think I have a good idea of what the outcome of this will be, and I know the applicant had asked before to consider a deferral if it looked like we were going towards something consistent with staff recommendation for disapproval, but we can't defer something on our own. So should we ask the applicant if they want to defer? Given what Robin has said, a study doesn't seem feasible. I don't know what a deferral would do, but maybe worth asking.
That's exactly what I was going to say, is if you would like to ask them to defer, if you could give us direction on what should take place in that 30 days. And keep in mind, is it a violation that's already been deferred once already?
What was that last?
It's already been deferred once already.
Okay, but, as far as if it being a violation, we don't have to take action today. The property owner has the right to defer.
Well, it is a violation.
Well, it is a violation, but we're not mandated to act on that violation.
If you'd like to defer, we would just like direction as to what you want to accomplish in that 30 days, because we know we're not going to get a study done in 30 days.
Robin, in the past, have we ever been in situations where we had something that needed study, staff doesn't have the resources, which I think that can happen, and it's not staff's fault or problem. It's just some of this stuff is complicated and requires a lot of fact-finding, where we've allowed an applicant to hire a consultant that's approved by staff in advance so they could rely on that person's opinion, because I don't think we can rely on the applicant to say, this is contributing and this is original siting. But if there's someone else, maybe they give them an opportunity to engage someone that would cost a lot less than tearing all this off and let them try to make their case without staff having to do the legwork, and someone you'd be comfortable relying on.
Well, I don't know whether they have the resources, but would you have recommendations of people that they should use?
It would need to be someone that met the Secretary of Interior standards, qualifications.
But, you all have some people.
Yes. My guess is, again, that's probably not going to happen in 30 days, because that is going out and measuring hundreds of properties. And I'll just reiterate one more time, this is a rule that's been in place for more than 20 years. So I hate for us to make a snap decision and change it based on a violation when so many people have been required to meet the rule. I have a list of 11 that we could just think of off the top of our heads of properties that had the same situation and they were made to remove siding on an entire house.
I'm not suggesting that based on that we would change the rule. It would be if there was a qualified consultant that could make the case that this district is actually very different and that it's worthy of an exception. Not that we're changing the rule. I don't think we should change the rule. There's a lot of people who've relied on that rule and complied with that rule, and it would be unfair and arbitrary to change it. But I think there is a way that someone can make a case that this situation is different. I think it's a very hard case to make, but I'm looking for a solution that is less
That's not a disapproval. I think
the solution could be worse than the problem.
Aaron, if I don't want to put words in your mouth, but you're unconvinced by what's been presented today, I think is.
Yeah, I think someone who's qualified, in the staff's opinion, to evaluate each individual home, that requires a fair amount of skill and just to be comfortable that it's the original siding and not replacement. I think those examples are going to be really hard to find and prove, but if someone could do that, I think that would be persuasive towards an exception. I think it's a really steep hill for them to climb, but it was more of a question, have we ever done anything like that before? Maybe it's a bad idea.
Oh, and all of this is probably a lot we got to think about, because this could lead to every single thing, everything we bring up might have we hired so-and-so to, every questioning everything. Like I said, I'd personally feel different if it was brought to us originally. And, hey, guys, we did a study and we look at 7 inches. Then it was one thing. But, just, think about these plans were submitted. They were approved. There were notes on the drawings. It was drawn correctly, and it was constructed. My first case, someone had put up vinyl siding, and they had to take it off, and it was terrible, but it was something that we stuck with because that's what is on there. And I'm not saying vinyl siding is a different story, but we just had to be, with a violation, we just had to be careful with our violations. I'd be different if it was not a violation. We just, it's almost in why review it, but.
I think one of the things, too, we recognize this hardship that it places on this owner. And we have granted exceptions due to hardships, but there are always circumstantial hardships based on the geography of the site or structural conditions or other things. And I don't think that we can base anything on a hardship that's, in essence, caused by a lack of attention to the documents. And so I don't see anything today that supports us granting an exception to that.
Yeah, and even if it were brought to us before that, I mean, we still have that standard. And when Hardiplank was even considered as a new product, there was so much discussion about the smooth versus embossed and the 5 versus whatever. I mean, it was a long discussion, and that the Hardiplank was, I mean, that was a sort of solid recommendation if that's the project you chose to use.
But either way, if we get a motion, we can get out there. I can't make it.
With respect to 532nd Avenue South, I move to disapprove the request but to go back to staff recommendations and charge the staff to work with the owner to solve the foundation condition, but with respect to the siding, to agree with staff recommendations.
Okay, we have a motion. Do we have a second?
Second.
Okay, all in favor?
Aye.
All opposed? Okay, motion carries. 111 4th Avenue South.
Here at 111 4th Avenue South is a 2-story commercial building. It was constructed prior to 1897. The building is brick with a hipped roof. Hipped roofs are rare for buildings of this type downtown, but the hipped roof does appear to be original. The applicant is proposing to construct a rooftop addition and roof deck. The railing on the deck would begin 8 feet back from the front of the building, and the enclosed portion of the addition would begin 30 feet back from the front of the building. There's the left side, front view, rear, floor plan, roof plan. The setbacks are the numbers of the setbacks, an 8-foot for the railing and 30-foot for the enclosed addition, are the minimums that are required for rooftop additions for many buildings, but of course many buildings are flat roofed. In order to construct the addition on this building, it would require the removal of the original hipped roof. Demolition or removal of original features is not appropriate under sections of the guidelines pertaining to additions and those pertaining to demolition as well. You can see in these aerial renderings. The application also includes extending an existing external stair there up to meet the new 3rd level proposed. As I said, the stair tower is existing, although it was constructed sometime after a rear addition was approved in 2007. It's not clear whether the side stair itself was actually approved, but sort of that's of lesser consequence than the proposed rooftop addition, which staff recommends disapproval of the rooftop addition, finding that it doesn't meet the design guidelines for rehabilitation, additions, or demolition.
Any questions for Sean at this time?
Most of the buildings in this district, I think, have flat roofs. Are there others with roof forms that aren't flat like this one?
I know of 3 with gable roofs, and those have been dealt with differently than a typical flat roof parapet building.
To my knowledge, at least that I can think of at the moment, this is the only hipped roof.
All right. Thanks, Sean. Would the applicant like to come forward and state your name and address?
Well, my name is John Tissell. I'm the architect working with the owner on this project. Just like to make a few brief points in support of the application. First of all, it's true there is a hipped roof on this project. We are not sure how old this roof is, if it is original. Looking at the framing, it does appear to be fairly old, but I don't think there's conclusive proof one way or the other, as far as I know, that it is original. Another point, this lot, another point about the roof is that, as you can see in some of those photos, the roof has a fairly low pitch and is not very visible. From across the street and within probably 100 feet of the building, it's hard to see the roof at all. You have to get quite a distance away to even tell that there is a hipped roof on the building. And that, as in the view that we're showing right now on the screen, even after the roof is removed and this deck would put on, you wouldn't be able to see where the hipped roof had been in that case. We'd have to be way down the street at Broadway. And the third point is this lot is a little unusually is not very deep compared to other lots in the area, so that on a deeper lot on Broadway, for instance, there would be much more flexibility to keep more of the roof in the front, build a deck, and build an interior addition that allowed access to the deck. Whereas in this case, because the lot is so shallow, the owner is restricted and really trying to find a way to allow them to do things that other property owners have done when they have much more freedom on their lot. Thank you.
Good afternoon. I'm Brian Neal. I'm an attorney working with the applicant. I work at Byrne Foreman. I live in East Nashville, 1309 Ordway Place. We find ourselves in the opposite position of the previous person you heard from. They were asking for an exception where you traditionally denied one. I'm asking for an exception where you've traditionally granted one. We have submitted a slightly revised version of this in the last few days that adds 2 chimneys to the front. I thought there were 5 chimneys. There are 5 chimneys. They were all going to be removed per there. We're keeping the 2 closest to the front facade, closest to the street in the new drawings. And so mainly I think this is about the hip roof. That's what I heard about. Let's talk about the roof. The historic photo that was attached to the staff recommendation, you don't see the roof in it. In the current photo, you don't see the roof in it from directly across the street. I don't know if the roof was there in the historic photo or not, but it's quite possible it's the same elevation and profile as today. Staff recommendations note that you have to move, what's the quote? The hipped roof is visible from far down the street, but not from a closer vantage point. And it's a low-rise asphalt roof that's partially obscured by the Hilton Hotel that was allowed to be built next door to us 15 to 20 years ago at a higher elevation, blocking the north-facing view of the roof. So why was this denied? As I read it, it would obscure or contribute to the loss of a historic character-defining feature. We submit that this hipped roof that's barely visible, if visible at all, constructed of asphalt, is not a historic character-defining feature. What I passed out before you are other examples that I think show where the staff has recommended and you have approved instances of similar questions of is this a historic character-defining feature, and the finding was that they were not. The first you'll see there is from the 208-210 Broadway project. That, as I understand it, has not yet been constructed. I think it's known as the Redneck Riviera when it was approved in November. There you have a pre-Civil War residence on the left. This should be the first photo in what I handed out to you guys. The project called for blowing out the side of the brick facade wall there overlooking the shorter building so that they could have ingress and egress onto that rooftop. That was approved. The holes that were contemplated and approved are doors, windows, and garage-sized doors. Even though it's visible from Broadway, from the rear and the front, the reason that it was approved, these openings were approved, is that it would be appropriate, even though they would be visible because they, quote, do not affect the primary look and character of the building and would not impact any character-defining features. So brick facade, clearly visible from Broadway, not a character-defining feature, and that wouldn't primarily affect the look. That was how we got around it then for a rooftop deck. Also, windows are removed on this building on the side of the building, and we found that that wasn't a public facade, and the windows are not character-defining features also. So we submit that the board has had submittals proposed to it that have been recommended for approval by the staff, where the interpretation of the design guidelines with regard to visibility, character-defining features, and public facade have been quite generously interpreted in favor of rooftop additions. And this departure here would be arbitrary. I heard earlier in the last applicant that it's very arbitrary to find an exception here where not before. That was part of what we talked about or heard you discuss on the Hardy board. It'd be hard to find an exception here where we've told so many other applicants that we're not going to approve it. I submit that this is the opposite of that. Here, we're asking to do something that is going to be less impactful, barely visible, if visible at all. And previously, this board, the staff's gotten around that problem by finding that it didn't primarily affect the look or character of the building, the facade, that it wasn't a character-defining feature. So moving on, a few pages ahead, but what I've given you, there are photos of it, excerpts from the recommendation. We don't have after photos because it hasn't been constructed yet, to my knowledge. Next, I have before you 104 Fifth Avenue, until recently known as Pub 5. There were questions a minute ago about are there other buildings in the district where we have something other than a flat roof. The answer was yes. One of those is Pub 5. It was a gabled roof. In the recommendation, I've given you excerpts again there, staff noted that it had a roof shape, height, and depth that was somewhat unique for the district. With regard to these unique aspects, you had a low-sloped gabled roof. It was the shortest building on the block, and it was the least deep building on the block. It's the closest to the street. It's very impactful. Regardless of those things, staff recommended approval of a rooftop deck with setting aside the 30-foot restriction that we're obeying. Why? The answer was because these unique conditions there, the staff recognizes that a lesser setback is necessary to allow for rooftop use. So there, unique situation, whatever else, we interpret that as a reason to set aside the rules and allow the rooftop deck. And finally, I've given you some photos of Tootsie's. This will be quick. It's on the chimney, actually. The first photo there, this is the last 3 pages. The first photo is a picture of the existing Tootsie's as we see it. I think it's from Google Maps 6 months ago. But in the historic overlay guidelines, you have a photo of the chimney that used to be there. And it's deemed an important, a significant chimney, one we should save, one we should design exemplars of in the future. That chimney's missing now on the new rooftop design. And I know there's litigation ensuing about Tootsie's, but there's not one mention in the complaint that was filed about the chimney that's missing. Why? I don't know. I don't have the submittal. It's too old. It's before 2012. We can't track it here. But I submit it's probably because the chimney wasn't an architecturally significant feature. So I'm not here to tell you to let us do it because you've let everybody else do it. That's not my message. There are 9 other, by my count, projects in this district where rooftop bars have been approved in the last 5 years. What I'm asking you to do is avoid arbitrariness. I'm asking you to apply the rules as they've been interpreted for at least the last 5 years. And how have we interpreted low visibility, low impact rooftops in this district? We've interpreted them in ways that allow us to build rooftops, is what we've been doing. Regardless of what the guidelines have said, we've found that if it's not a public facade, well, we're not worried about it. Or if it's low visibility, or it's not a historically important or significant portion of the building, then permission granted. And we submit this hip roof that you can only see from certain vantage points is one of those type of characteristics. We're not touching the front facade of the building. Will appear no different from your normal vantage points, and as a result, we ask that you stray away from the recommendation from the staff. Find that this isn't a character-defining feature. The loss of the chimneys, and it'd be 3 chimneys instead of 5, the loss of the hip roof, not character-defining, would be minimally visible, this project, and that it does not affect the primary look and character of the district or the building. And thank you.
Okay, thank you very much. Okay, I'd like to open public hearing. Would anyone like to speak regarding this project? Okay, seeing none. Did you have one? No? Okay. Seeing none, close public hearing. Discussion.
I have a question. I mean, it's not specific to this, but, you know, we were addressed by the federal historic guidelines that at some point we were going to lose our historic designation if, in fact, we continued the additions of all these rooftops. How close are we to that? Do we know?
I can't give you a definitive answer on that. I mean, in my discussions with the state, we're very close, if not over that line. But
I mean, I just, you know, I think in our designation and our charge is that we probably ought to start paying a little bit more attention to that in itself. And unfortunately, it's been the first come, first serve kind of thing, but we certainly want to exercise good judgment when it comes to that.
Sean, can you click back to the earlier photos of the building as it exists today? Thanks. I know that we've made exceptions with gabled in the past and with rooftop decks behind the gable.
I wouldn't say it's an exception because the original.
Well, they found that it complied.
Because the original roof form remained, and the
Right.
addition was behind the gable.
But that opportunity is not here because it's a hipped roof.
It's the original.
And that's what I was going to ask. Is the original hip roof? I guess I wanted to clarify. That is the main thing. I know the other points about it being visible, but the main thing is they're asking to demolish an existing, looks like to the existing building, to tear it out, to put on a flat roof.
I feel like this one, for me, gets back to the Secretary of Interior standards, which I think the staff had referenced, which is if you're taking off a character-defining feature, and the roof's pretty significant. I mean, I know that there's been some presentation that it's minimally visible and some of those other things, and even some cases brought forth that some piece of it remains on other applications is not insignificant, but I think to tear this, I find that a specious argument to tear the roof off and offer no history of its being there. I would say, well, then what's character defining about the addition? Let's just take the railing off. It's not in compliance. At that point, this is somewhat of a non-starter in terms of what the proposal is, and right at the word demolition of the roof, notwithstanding the applicant's presentation.
I agree with that, Ben, and I don't know, I walk on the street all the time, and I have to kind of disagree with the applicant that it's not noticeable. I mean, you can see the roof from these photos, and you can see it from across the street. Since it's kind of a freestanding building almost, in a way, it's not, in a row. It is visible, and it is different, and the chimneys are very significant. It's just got a very interesting look, and I think that, is important to maintain.
I guess I'll further add to that because the guidelines permit a rooftop use doesn't necessarily guarantee that that every building. One could make that argument, but I think in this case, because of what's stripped off and what you put back, that just because it doesn't seem to meet the standard in any way to me.
Anyone else have any discussion? Do we have a motion? Agree with staff recommend, or whatever.
I make a motion to disapprove of the proposed rooftop addition for 111 4th Avenue South in regards to all staff recommendations.
Okay, we have a motion. Do we have a second? Okay, we have a motion and a second. All in favor? Aye. All opposed? Okay, motion carries. 714 Shelby Avenue.
This is an application for new construction of a residence on this vacant lot. The proposed building is a story and a half with a height of 27 feet from grade. It is 40 feet wide. The height and width are within the range established by neighboring buildings. Has a split-face block foundation, shingled roof, fiber cement siding as the primary cladding. Staff finds that the proposal meets the design guidelines for setback, rhythm of spacing, materials, orientation, and proportion and rhythm of openings. We listed a few conditions on these sections in our report. However, staff finds that the proposal did not meet the sections on building and roof shape, primarily due to the projecting front bay you see in the front elevation. There are examples of a projecting front bay in the district, some examples here, but these are normally offset to one side of a porch and are also subordinate to the main roof of the house. Therefore, as submitted, staff finds that the building does not meet the design guidelines for building shape and roof form. Staff and the applicant went over different options for this, but as redesigning this portion of the building constitutes several alterations, our recommendation, staff's recommendation, is for disapproval, finding that the application does not meet sections 3B2C and 3B2D of Edgefield's design guidelines. And I believe the applicant is here.
Okay. Any questions for Paul? All right, thanks. Would the applicant like to come forward and state your name and address?
Are they on here? Yeah. Hi, my name is Jason Corum. I live in East Nashville, Lockland Springs. And I submitted these plans to be built or be constructed. I've been working with Historic, I've gone through many different iterations of the plan, and I thought I was almost there. Thought I was going to be approved with conditions to work out the details with staff. And I guess my goal is today is to get the overall design worked out and then work out the details with staff, so approval on conditions with staff. Let's see. Oh, that's it. So this was the kind of the inspiration or scaling for the current design. A central feature coming out the middle and then leaving room in the roof to block the massing of the side gable. So that's the current design. And also, since this is a duplex, the central feature allows for 2 porches, and so you know that it's a duplex. It also allows for privacy on the front porches from the adjacent unit, but it still engages the street. There's lots of openings, lots of windows. I've changed some of the design originally to put the door on the front facade and make the windows larger, and that Historic, I think, is all fine with. It's just the central feature. So in our conversations with different solutions, they presented these 2 images as examples. The lower option is kind of similar to the current design, except that the side gable is mirrored on both sides, since it's a duplex and not a single-family home. And then I do have an option B, which is Well, option B, and this is an approved plan at 1406 Holly Street with a central gable and a bump out. So option B is patterned after this, but not as massive on the top. The central gable is lower. It doesn't go up to the top of the side gable, making it less massive and also allowing it to be dormers on the side too. But then this one, which I think some feedback shared, they didn't want the central feature. They wanted a porch around it. So now this one, the porch wraps the entire front, similar to this one that's been approved previously. I could go either way. I just want to.
Can I interrupt you? Ask you a question. You're giving us sort of options, and are you looking for just direction on what?
I mean, I prefer option A.
Well, I mean, that's what's before us.
Right.
That is what is before us, and that's what we'll rule on. I don't understand sort of what we're.
Yeah.
Where we're going. So help me.
I guess my
understand.
goal is to not get deferred and have to wait another month. I'd like to get plan approval on conditions so that I don't have to wait for another meeting to start over again.
I don't think we can. I mean, we have to act on what's before us.
Okay.
Okay. Now, and I mean, you can work with staff. I mean, not today, but I mean, we can't act on anything that's not been reviewed totally with them.
Okay.
By them.
Well, I guess I would prefer approval on the current design. I think it meets scale, and since it's a duplex, it takes the similar form of what's in the area, and yeah, I would like it to be approved.
Okay, any questions for the applicant? Other questions? Okay, thank you. Open public hearing. Would anyone like to speak regarding this project? Okay, seeing none, closed public hearing. Discussion?
I think it's an interesting question because I don't feel like we've seen this kind of design before. And I'm trying to think about, in my mind, historical examples in this neighborhood of duplexes, and there definitely are some. I think most often they just share a front porch without this dominant piece in the middle, but there's other ones where it's flat across the front and there's separate porches, but they're sort of recessed. To me, that's not all that much different than this protruding in the front. And I guess maybe those others where it's recessed are trying to imagine what the front elevation on the second floor, how that works, but maybe there was more massing on the top, so it didn't appear to be so dominant in the center. But to me, it's not objectionable that you've separated the front porches. I think that there's examples that historically I'm just having trouble coming up with exactly what that looked like, and I'm curious what other people think about that, and what staff looked at in terms of those kinds of examples, shared versus separated front porches. Because one of the things I think is odd that we approve regularly is duplexes that look like single-family homes. I don't see why they need to look like single-family homes. There's examples of historical duplexes that are clearly two-family homes.
Yeah, I just don't know that there are that many duplexes in Edgefield. And if they
maybe not
are,
Edgefield exactly, but in East Nashville and Lockland Springs.
Yeah, but if they are, they look like or have been used as single-family homes at one time.
For us, it wasn't an issue of two separate porches or the porches being separated, because there are lots of duplexes with historic duplexes with two different porches. For us, it was just more of the overall form. And if it had been as easy as a couple of conditions of, move this here, move that there, then we would have just made a recommendation for approval with conditions. But we thought that there probably need a little more work done to the overall form so it wasn't something that could be captured in conditions. Mr. Hoffman may have said this and I missed it, but I did want to remind you that you received an email from the neighborhood recommending disapproval. Just want to make sure that was on the record, in case you didn't say.
Did the owner try to work with you all to sort of mediate some of the issues that we had, or just this was it? And
For this one, they were recommending disapproval of this design. I mean, again, an applicant can present as many designs to you as they'd like.
There was so much to consider that there was no place to start the discussion, I guess.
I think they provided, and honestly, I can't remember because it was a little bit of a rush this morning. I think they provided some specific guidance, but again, it wasn't things that we felt could be incorporated into conditions.
A few, I guess, comments. One would, as a total project, the scale of it being a duplex, I applaud the restraint shown by the applicant in that we've seen so much more crammed onto, into, or at least attempted to be crammed into a two-family residence. So, not that everything here is all bad, but some of the, Aaron, it's a difficult challenge, and we've seen some more successful and other not so successful ways to try to create a two-family entrance that fits in historic context. We've seen things as clumsy as even violation cases that install the old screen wall between the two porches to provide that single-family feel in a two-family residence, which sometimes I guess those two things aren't necessarily congruent. Here, I agree with staff's analysis of this. While maybe a useful solution to that privacy issue of a two-family entrance on facing the street, the hierarchy created by the two-story form is a little bit backwards. That's the most important thing, and typically, not in every case, but in most cases, you can look at, and some of the examples that were put up on the screen at the beginning of this case was, it looks appropriate in that the front door has more hierarchy than some other piece in a bifurcated facade, and when it's not, it is set off to the side, and this one sort of tries to marry the two of those together, and there's not that it muddles and confuses what one would expect in the hierarchy of a street-facing facade. And I know we're not here to review something that hasn't been seen by the staff, or that just has a lot of other things that they would need to comment on, but having the porch rack read all the way across the front of the house, I think, is something that presents a facade that is more in keeping with the guidelines in terms of the significance of the entry and how you accomplish that in a two-family house.
You can also almost see kind of Robin's point that, you can see they worked at it, but they just didn't get there. So based on what we have, we just can't.
And I'm not advocating for approval of it without the applicant seeing it. When I look at this application, that's the confusion that I see between this forward front-facing center gable in a biaxially same facade. That's the thing about it, that while it accomplishes the privacy on the porch, it doesn't necessarily fit in with the rhythm of what you would typically see on a front facade.
We may be able to go on into a motion from that.
So with respect to the application for 714 Shelby Avenue, I would move for disapproval as presented based on the staff's recommendation.
Second.
Okay, we have a motion and a second. All in favor?
Aye.
All opposed? Okay, motion carries. So now we have 1239 6th Avenue North, which was moved from consent. Part of the new actions.
There was a violation before that. Do you want to
I apologize. I thought it was deferred.
Oh,
Oh, okay. That was my fault. I thought it was deferred.
So
144 Windsor.
140 Windsor is back? Okay. So 144 Windsor Drive is on the agenda.
Okay, there we go. Found it. Okay, 144 Windsor Drive is located within the Bellmead Links Neighborhood Conservation Zoning Overlay. It's highlighted there in red. You can see that the site backs up to an area that is not part of the conservation overlay. Here's an aerial view of the house in question. The house in question, 144 Windsor, was constructed in 1991 before the overlay was in place and is considered to be non-contributing. In 2011, MHCC approved a rear addition and alterations to the non-contributing house. In April of this year, the Codes Department notified MHCC staff of construction taking place without a permit and without both a codes permit and a preservation permit. The work was the construction of a green wall system. At the April 19th, 2017 MHC public hearing last month, the Historic Zoning Commission disapproved the applicant's request to keep the green wall structure in its entirety without any changes to it. This current request is a revision to the disapproved plans. So you can see here, highlighted in red is the location on the house where the green wall system was constructed. It's entirely on the addition to the non-contributing house. So here is a photograph taken from the street without any zoom of the green wall system. The arrow is pointing to it. It's poles, and I'll show some more up-close pictures here in a minute. That's poles with some mesh connecting the poles, and the purpose is for plants to grow up from planters below to kind of create a screen. And you can see here in the photo that the dark gray kind of two-story structure behind it, that's actually not part of the this house, but it's a house next, kind of behind. It's a different lot behind this lot. Here's a picture of the green wall system taken from the street but zoomed in, so it's not quite how you see it from the street, but it gives you a little bit more detail of what it looks like. Here's a picture taken from inside the house, so this is not something that you would see from the street, showing the rear part of the green wall system. Again, the purpose is for the plants at the planters to eventually grow up and to create a screen. The portion at the rear, this is the very rear of the property or of the addition, is 8 feet in height. And here's a picture of the green wall system along the side. That is lower in height. That is 4 feet in height. The pole height is the same, but the actual mesh, the fencing, is 4 feet, and it's lower. So here again is the aerial showing the location of the green wall system. And so again, the back portion is 8 feet, and then the other portions along the side and kind of towards the front is 4 feet. So staff is recommending that the part of the green roof system that is most visible along the right perimeter of the house be removed. Staff finds that the other sections are only minimally visible from the street and therefore could be appropriate. In our analysis, staff notes that 144 Windsor backs up to an area that is not in the conservation overlay and includes a new home that is significantly taller than any homes in the area. This area was taken before the construction of the infill behind it, so you can't see it in this area, unfortunately. Staff did have some concern that a similar wall may be proposed for the many rooftop decks the Commission has approved in recent years, and we suggest that this rear green wall is appropriate only because the building is non-contributing. The proposed wall is only minimally exceeds the existing eave height on the rear, and the property backs up to an area that is outside the overlay. So in conclusion, staff is recommending approval of the work with the condition that the applicant remove the portion of the green wall along the right side facade. And the applicant is here. I believe it's her intention to maybe work to see if there's another solution to create some sort of screening, but she can talk a little bit more about that. So this might come back with some additional changes to in the future, but since it's a violation, we wanted to bring it forward to you this month.
Okay, thank you. Any questions from Melissa? right, would the applicant like to come forward? And
Sorry, I just have one
please,
question.
please.
You're recommending removal of the side. Why not the front piece, the little stub?
When you look at it,
You don't see that?
it says, yeah, I mean, if you look at the picture, really,
You
it's
don't
the
see it
side.
from the street because it's tucked in?
This is where you can, so this view right here is actually where you can see it the most. You can't, because if you go further down, if you go further either way, this is where it's most visible. And here's the zoom portion. So, I mean, there is greenery there, which is probably why you can't see it right now. And typically the commission doesn't consider landscaping, but, so you could, the staff felt that what you see most in this view here is that side portion, and that's what had the most impact. So that was our opinion.
Additional question along those lines, as this was possibly used as justification for maybe something in a different district with a whole different set of guidelines, and this, my question really, I guess, gets more towards your statement, which is we really don't review landscaping, because this system requires a built support system. Would you feel differently about trees that were in planters in terms of mass form and some of those things?
We would not. So if there was a case where there were trees and planters or bamboo and planters, that would not be reviewed by us because the planters are removable. But this is, because it's a structure, it's a wall system, it does fall under a review.
That was my curiosity, I guess, and maybe a legal distinction that someone planted a tree that 30 years from now provided the same obstruction.
Right.
How
And
different
even on top
would
of
that be?
even on top of the roof, here, if there were planters that would do the same thing with screening, they would, if they were inside the wall perimeter, even if they're.
It wouldn't come before us.
Yeah.
Thank you.
All right, any more questions? Okay, thank you. Would the applicant like to come forward and state your name and address?
My name is Jackie Daniel, and I'm the homeowner of 144 Windsor Drive. Once again, I'd like to apologize for not applying for a permit, but I do want you to know that I did go to the Metro Zoning Board and talk to Byron Hall, and he did not mention that I needed one for this and that I needed to get a historical permit. It was not an intentional oversight. I've provided a sheet with examples similar to the green screen I have installed. I'm willing to remove the longest side section recommended by the commission, and I look forward to working with them toward an alternative solution. What would remain and is recommended for approval, I feel has little to no visibility from the public right-of-way and our overlay. The product itself is 95% transparent. This remaining section recommended for approval runs along only part of the rear property line, which is adjacent in entirety to a Metro sewage easement. Beyond that is a neighborhood not in the historical overlay. I believe it is architecturally appropriate for the design style of my house. And finally, the intent and purpose of this planting screen is to regain the privacy lost to the 45-foot tall structure, which unexpectedly showed up behind my rear courtyard, less than 20 feet away from the rear wall of my courtyard in January. Thank you.
So if I understand, you're agreeing with staff recommendation?
Yes.
Okay, thought that was to make sure. Okay, any questions to the applicant? All right, thank you. Open public hearing. Would anyone like to speak regarding this project? Okay, seeing none, close public hearing. Discussion or a motion?
I'll move to adopt staff recommendation.
Second.
Okay, we have a motion and a second. All in favor? Aye. All opposed? Okay, motion carries. 1239 6th Avenue North.
(1239) 6th Avenue North is a circa 1890s brick commercial structure that contributes to the historic character of the Germantown Historic Preservation Overlay. Most of you probably know it used to be the Mad Platter restaurant. The application is to alter the storefront, demolish an existing addition, and construct a new addition. So first, the applicant is intending to remove the existing addition at the rear. The exact date of construction of this addition is unknown. It seems to have been built in stages, kind of first was a ground floor, then it was 2 stories, and it was widened. But in looking at it, staff felt that the addition did not contribute to the historic character of the historic structure and recommends approval of the existing, recommends approval of the demolition of the existing addition. Here's the site plan showing the footprint of the existing addition and the footprint of the new addition that's being proposed. On the left side, the addition does extend out beyond the side wall of the historic structure to be 4 feet wider than the historic structure. Staff finds that this wider portion is appropriate because it will only be minimally visible from the street and it will not denigrate the existing historic structure's character. Here's a photograph and a rendering of the front facade. The applicant is proposing few changes to the historic structure. Basically, the wood trim will be painted, which is appropriate. They're not painting the historic brick. And then the tiles that are underneath the storefront, those tiles aren't original to the storefront, but they replicate an historic condition, so they will either keep them as is or replace them in kind. And so more about the addition. The addition will be 2 stories and will match the height of the lower parapet part of the historic structure, which staff finds to be appropriate. There will be a 6-inch by 6-inch deep channel separating the addition from the historic structure on the Monroe facade. Because the existing addition that is to be removed did not inset, and because there is a change in materials from the brick to, they're showing here a hardy panel, but I'll get some of the materials more in a minute. Staff finds that a larger inset is not necessary in this case, and we find that the proposed inset is appropriate. The ground floor of the proposed additions has a series of 4 square windows that replicate the look of the storefront transom windows. Because the addition is modern in design and because the side street facades of commercial structures historically had minimal and utilitarian window openings, staff finds that these 4 square window openings are appropriate. On the upper level of the addition is a larger picture window, and that opening will not be operable. And then there's also an open-air covered space within the walls of the addition. Staff finds that the second-story open-air feature to be a modern interpretation of a historic rear 2-story porch. And I didn't mention earlier, but there is indication from looking at old Sanborn maps that the original addition to this was a 2-story porch element. The Sanborn maps show a 2-story porch element, and staff therefore finds that the open second story to be appropriate. Here is the interior lot side. You probably won't see this from the street, and because of that, staff finds that those horizontal window openings, which we typically don't like, to be appropriate because most likely you will not see this from the street. And here is the rear facade, which will be visible because this is a corner lot. I want to talk just a little bit about the materials. The primary cladding material for the addition was drawn as fiber cement rain screen. Staff did find that that met the design guidelines. However, I think there's been conversations between the neighborhood and the applicant about changing the material. Staff would be open to a different material as well. So we are just changing, well, I'll go back. We would just say that if the cladding material does change, we just will want to make sure that that material does meet our design guidelines, and we'll want to make final approval of that material. Here are just some floor plans. So in conclusion, staff recommends approval with the following conditions. Staff approve the final choice for the cladding material. Staff approve the final details for the windows and doors. We approve the material and design of the balcony railing and of the new awnings on the proposed addition. I didn't actually point those out. Let's go back. There's just these small awnings at the top, kind of around the open air portion. And we approve the location of the HVAC units and other utilities. And because this is a preservation overlay where we review all permanent landscape features, we'll want to review any fencing, signage, permanent fixtures. It does look like there'll be a courtyard area. We haven't gotten any details about that, so we will want to do that under a separate approval. And the applicant is here, and I believe there's also people here to talk from the public.
Okay. Thanks, Melissa. Any questions for Melissa before? Okay, thanks. Would the applicant like to come forward and state your name and address?
Hello, my name is Remick Moore. I'm the architect on the project, and I've brought with me Sarah Milkey, the lead designer on the project. Together, we've been given the daunting task of adding a new face to this, one of the most iconic buildings in Germantown. So we realize the importance of that, and we've been working with the Historic Germantown Neighborhood Development Committee and seek approval with conditions so we can move forward. Thank you.
Okay, did you have, okay. All right, open public hearing. Would anyone like to speak regarding this project? So come forward and state your name and address.
Hey, my name is Sonia Link, 4437 Jackson Road, Whites Creek, Tennessee. I'm one of the co-chairs for the Germantown Development Committee, and the committee appreciates the proposed addition that is only 12 feet deeper than the existing addition, and the lots not being overbuilt. We also appreciate that green space is being preserved and going to be allocated for use by courtyard. However, we do have concerns about the use of the cement panels as the exterior material and some of the lack of detail on the current design. Whereas the cement panels have been approved and used for other projects in Germantown, I can't think of a project where they have been used on an addition to a historic building. I do not think that they're appropriate for this project and feel that the material should reflect other buildings in the area. We would also like to see some details added to the design, especially along Monroe Street. This is a highly visible project to one of Germantown's signature buildings, and we think that the work should reflect this. The applicants are aware of our concerns and have indicated that they're willing to make revisions to address these concerns. In order to not delay the project, we hope that the commission will approve the project with the conditions that a more appropriate exterior material be used and that the applicant work with the staff and the development committee to add some design details.
Okay, thank you. Would anyone else like to speak regarding this project?
I'm Burdell Campbell, and I live on 5th Avenue North. Germantown started off with me and vice versa. So that was about 37 years ago. And as you're probably aware, we are daily, constantly striving to find ourselves and keep finding ourselves as lots of exciting things are happening. This building is uniquely significant for every reason that could exist in a historic neighborhood. It's one of the oldies. It was one of the interesting peoples and kinds of things that have happened to it, and it's been a landmark for all of us with the Mad Platter. It's on a unique corner. It's sort of the entry into the original historic Germantown, and it really deserves some special attention, and I think it's getting it. And with the things that's outlined here, it certainly could be that gateway into, this is what old Germantown in its restored condition has looked like, and we'd like to maintain that. The use of, she has covered the issues, the selection of materials, and that design needs some tweaking and some special attention just because it's a very special place. Thank you.
Thank you. Anyone else? Okay. Close public hearing. Discussion.
I'm going to go.
I would like to add for the record, Mr. Chair, I am a member of the Development Committee in Germantown, but I've not previously seen this project nor had discussion with any members of the committee about it. So just in full disclosure, wanted to say that.
Okay.
I feel like I can remain impartial to review it.
But I guess before, are you, as legal, comfortable with that?
I'm assuming that you don't have any sort of financial interest or anything like that in this?
None whatsoever.
In this project? Yeah, it's totally fine.
Okay, thank you. Okay, Renee?
Okay, so I don't know if it's disclosure, but it's my neighborhood as well, but I do not have any financial benefit from this. And to start off with, just I appreciate the neighborhood's openness to work with the developer. It seems that it's pretty workable that this can happen. I did look at some of the guidelines here about the walls and exterior materials, and it makes reference to original building materials should be retained whenever possible, which is on page 3, and page 7 references as well, materials as well would be masonry and brick and stone. So I guess the question is, the choice of the cement board would be a question for me, is if the guidelines does say this, is how that was chosen. So with that discussion, it's workable, definitely.
Okay.
I think, it is a landmark building, and I think anybody that knows Germantown really knows this building. I do think that the new design has been sensitive in a lot of ways and certainly conforms with the Secretary of the Interior standards for differentiating between the historic building and the addition to it. And I would hope that that wouldn't be lost as you move forward with evaluating other materials. I would personally encourage the applicant to work with the neighborhood and with the staff for evaluation of either these or other materials. But I would move approval based on staff recommendations and with those words of encouragement.
Okay, we have a motion and a second. Everybody understand that, so that the applicant is going to go back and work with staff and with the neighborhood on the selection of the materials, which is part of the, Robin, does that sound clear from you? You're looking like maybe it's not.
I think there, and I'm not saying that this has to be part of your motion, I just wanted to make sure. I think there were 2 things the neighborhood had asked for. I didn't really hear them as part of the motion. And that was materials, which I know you said you encouraged, but did you want that to be a part of the motion, and detailing of the addition?
I'll amend the motion to ask that the applicant meet with the neighborhood to discuss their concerns and then work with staff to on any change in materials. Would that address that? With respect to both materials and details.
Okay. Do you approve that? Okay. I'm just going to go with that, if that's okay, instead of approving the amendment. Okay, all in favor?
Just a question. Are we saying does this motion approve it as submitted with encouragement to continue to work on it, or this material and detail is not approved and is subject to staff approval on an administrative level to sign off? I think that's very important.
Yeah, and that is mine, but so maybe we do need to maybe be clear about that, since you're not sure. Yeah, since you're not sure. Maybe I'm thinking in my mind.
Could you elaborate on?
Well, personally, I very much like it when the additions, especially with a significant historical building, differentiate themselves to this degree. I think that's great, and it does a lot to preserve the original character of the building. I also acknowledge that a lot of people are not wild about the modern designs and that juxtaposition. I think it complies with the guidelines. Personal taste, not the guidelines. In the first places, I like it. But I just want to be, that's neither here nor there. I'm happy to approve it either way. I just want to be clear to staff and the applicant what we're actually saying.
I think the conditions, though, do sort of go a little bit more into detail about the staff approval with the dimensions and final details and doors and things like that. So I didn't take that as to mean that this was it.
Are we approving this, if this motion passes, are we saying the applicant, if after talking to staff and neighborhood just says, you know what, I need to do the cement panels, are they allowed to do that or not?
Is it, and thank you, because that wasn't totally clear to me as well. Here's just a thought for a motion. First condition, staff approve the material of the exterior cladding. In other words, saying this one is, what's presented is not appropriate. An applicant provide drawings showing an addition with greater detailing. And then all the other conditions that you see in your report.
So staff was not approving this amendment?
We recommended approval, but I think what the motion is saying is that the panels are not appropriate and that another material should be chosen.
So can he rescind the motion? Why don't you rescind it?
I'll rescind it.
Okay. So Commissioner Stewart has rescinded his original motion. So now let's craft one that's exactly what you intended, and then we'll
But real quick, are we saying that are we saying that this, how it is now, if they work, they go to staff, they work with the neighborhood, and, either they say, this is just what we're going to do, or are we saying that's not? If we craft a motion that we're amending staff recommendation number 1, are we saying that we're throwing the cement board out as an option for them? That's my question.
What I'm trying to figure out, and I'm sorry, keeping Cyril on the spot here, what was your original intent, and then we'll work from there.
I think it's important for the applicant to meet with the neighbors and to listen to concerns. These neighbors have been involved with this neighborhood for a long time, and I think that's important. It may well be that this is the right solution. It may not be the right solution. I do think I have confidence between the neighborhood, the applicant, and the staff that will wind up with the solution that's appropriate for this, that meets the Secretary of the Interior standards as well as our guidelines.
But the way I read that is that we're not necessarily eliminating this material. It's still an option. But the important thing is that we don't want to extend the brick and it look like a portion of the older building. It needs to look totally different. So that's the way I'm interpreting the motion that Cyril's made.
I think the Secretary of the Interior standards are pretty specific, that you don't try to copy what's there.
But I don't think yours is eliminating that as a possibility.
Right, that's correct.
Therefore, second your motion.
Well, so let's...
I feel like this is how people get upset in the end, because it puts it all on staff to bless something at the end when it's our job to do that. I feel like we should say if this material is appropriate or not. If we're saying it's appropriate, that's fine. I think that it is. But I don't know that everyone else agrees here. And I don't think it's fair to have staff in the middle of, if the neighborhood feels very differently and the applicant, this is what they want, to say, y'all go figure that out, otherwise it's good. I think it's our job to figure it out. I also don't want to discourage people from getting together and figuring it out for themselves, but I think we often put staff in, not often, but at times put staff in a position where it's really our job to make a decision, yay or nay, on something, and this might be one of them. If everybody's good with the cement fiber, then all we're doing is also encouraging the applicant to also keep talking, if you would, please.
But I think the difficulty with that is if we disapprove cement fiber, then do we approve metal panels? Do we, there's a whole world of materials out there that are different than fiber cement rain screen panels. And so if we disapprove that, then are you saying we have to approve something different?
Well, not necessarily, but I don't know that we would even have a basis given precedent to disapprove cement panels. I think aren't they a previously approved material?
They are, as Ms. Link noted, they definitely have been approved for infill. She noted that she couldn't think of any for an addition to a historic building, and I can't remember one either, not to say that there wasn't, but I don't remember one either.
The only 2 cents I was going to add is that the only reason why I wouldn't want to, I was reluctant to disapprove the fiber cement was kind of what you're saying. It is approved material, and it could be just in the detailing of it, and once there is detailing, because you're right, it definitely complies with the Secretary of Interior about really knowing the difference of the two. Perhaps there's a way that could be figured out from a detailing standpoint where it would be approved. And only reason why I'm not trying to make staff have to do more work, but they're more trained technically to walk through some of these things. Yeah. Well, not broad shoulders, but this is something they look at all often, and the applicant has been very open to work with the staff and with the neighborhood. So it seems like they probably could come to without an agreement. You got something, Ben?
I'll add, there's a great importance, I think, to item 2 as well when it comes to something that is a contrasting contemporary design. We have seen, I know we've seen lines on paper that, would look like a rain screen system, and then what you end up with is this big fat sort of standard. It's not a commentary on what the architect would do or even consider. I think he'd probably take great offense to what I'm about to say, given the documents and what the appeared intent is, but oftentimes we'll see in execution that there's a corner board where none was drawn, and then there's this big fat trim around the windows, and the contemporary design really falls apart with the details and how you detail a porch, an interior porch on a second story, and flashings that are at eyebrow awnings, and all those kinds of things are very important to whatever material is selected there. So I think number 2 is, that's not in disagreement with anything that's come before. It just that is equally as important, especially when you have this contrasting contemporary design.
Yeah.
So I'm just going to comment, not that I'm disapproving this, but I think what we always say is that what's before us is what we approve. So if this is the proposal that the developer has given us and we're going to approve it, then that's what it is. Not necessarily that, yes, we encourage them to talk to the neighborhood association and agree. If that's sort of a side note, but what we'll be approving is what is on paper today. So, and I have a little bit of a hesitation to do that because of the conversation that they would have with the neighborhood, and whatever they would do with staff and have it be approved. So I'm just a little bit on the fence about approving this as a final.
I think the first and second,
Well, the motion was rescinded, so there is no motion out there. No motion.
But the first 2 really do. I'm sorry.
I was backing off my chair.
No, she takes care of me. The first 2, I think, do address that, though, is that this is a basic design, and that they're going to work through the materials and the detail in conjunction with the staff, the architect, and the neighborhood.
Put the staff recommendation back up on the screen.
Yeah, I think the first piece is just approving the details of the cement fiber board, the way staff has recommended approval. That would, to me, approves that material, and staff will talk to them about details, but that material is approved. If everybody's good with that, I'm good with it. I just want to make sure we're not, if the majority disagrees, I want to make sure we didn't inadvertently approve it.
I just want to clarify that what's on the screen is slightly different than what's on the published staff recommendation. So on the screen, I had changed it because it sounded like the applicant was working with the neighborhood. So I just wanted to leave it open that if they choose. Yeah. So my intent was to leave it open in case there was another material. We would just want to make sure that material is something we would approve.
Let me just make sure. So that's different, but what's here is what we would be approving today. that's on.
Well, I think that's up to you. I mean, originally staff felt that the cement fiberboard panels were appropriate material and a material that we've approved in the past. I changed the presentation because it seemed like the applicant and the neighborhood were looking at exploring other options, and I just wanted to make sure that if there were other options on the table, that staff would have the opportunity to review those materials.
Well,
but staff found the cement fiberboard panels to be fine as long as we improved the installation technique.
Right, and here it says staff approved the final choice for the cladding material. So to me, that doesn't mean it's definitely cement fiberboard. I'm just not saying that I'm not disapproving it, but I'm just not as comfortable with it yet.
And I just wanted to throw out too, and I may be completely misunderstanding what the neighborhood said, but there was discussion about greater detailing on the addition. And I haven't heard you talk about that. And maybe that's not meant to be a part of a motion, but I just wanted to throw that out there because I don't think they meant the detailing of the material, which is very important. I think they meant other kinds of detailing, but I don't know.
That's the way
That would have been architectural details versus.
My impression of the public comments were when they meant details, it perhaps meant things like, should there be another window here, not the finer details of installation of cement fiberboard.
There was a nod to architectural.
But item 2 covers that, final details, dimensions, and materials and windows, and doors. So I feel like that would be all details, would it not?
No, that would just be the final details, dimension, materials of windows and doors.
Oh, okay.
So,
Shown, not adding or.
right, not adding windows, not adding
gotcha.
casings, not adding cornices. Now, I'm not saying there should be a cornice. I'm just throwing out, the impression I received was that the design was too simple. That doesn't have to be your decision. I'm just saying I want to make sure I understand
Well, that is
your
kind
final
of,
motion.
we are all talking about overall details. I think I was looking at 2, but I didn't read about it. It was to windows and doors. All of us have been saying details. Ben brought up specific details of windscreen, and Aaron brought up specific details of differentiating the materials. So yes, we would have to make sure we craft the motion, if that is still the consensus, that of not just of doors and windows, but the entire addition. So does anybody want to take I think the thing is, I think we're in consent in a way with all of us. We just need somebody to kind of concise it into.
I really think this new staff review that we see here is broad enough to cover of getting the 3 together and giving them the direction and options.
Well, except for 2. I mean, Robin pointed out correctly that is specifically windows and doors, and we need it also for the all the addition.
So let me take a stab at this.
Thank you.
With respect to 1239 6th Avenue North, I move that the applicant meet with the neighborhood to hear their concerns about materials and detailing, and that they work with staff, who will then work with the conditions as listed, as well as overall detailing of the building, which might include any recommendations from the neighborhood, and that staff use its judgment then for approval of these items that we've discussed.
Okay, we have a motion. Do we have a second?
Second.
Okay. Any more discussion about the motion?
I like that motion.
Okay. All in favor? All opposed? Okay, motion carries.
Thank you, sir.
All right. So we are at 927 Gilmore Avenue. We have been going for 2 hours. Does anyone need a break at all? Restroom or anything? Everybody good?
I'm going to take one break.
Well, let's make sure if anybody, we've been going for 2 hours. We could take a quick 5-minute break if you guys want to. Okay, we're going to take a quick 5-minute break. It's probably better.
Where's our cookie? I'm just kidding.
Try to give Caitlin one more minute. All right. I'll bring this month's meeting back into order with 927 Gilmore Avenue.
Okay, 927 Gilmore Avenue is a historic circa 1900 Victorian house with a hipped roof, and it has hipped dormers on the front and side slopes. And this is an application to construct a rear addition to the house. The addition will, well, I'll go show a couple more pictures. There's one from the right side, and there's from the left. This is a proposal to construct a rear addition. The addition will match the height of the, height of the house, the existing roof line, with the majority of the eaves that are either below the eave height of the existing house and a portion on this cross gable that matches. As I alluded to there, the addition has a cross gable, but the gable is a portion that matches the height of the original house, and then the connection between the cross gable and the existing is a saddle or a hyphen that's actually lower than the original roof. And although the addition is not taller, it does have a portion on the addition that is wider than the historic house, and that's it. The addition on this image is to the right, and the front being to the left. So the addition, as you see there, is about 8 feet wider than the historic house. It is not always appropriate for additions to be wider than historic houses, but the commission has found in situations like this where a house is less than 30 feet wide, shifted on one side of the lot, and if the wider portion is significantly far back from the front, that it may be appropriate. And staff finds that is the case here. There's the front elevation on top, and the side elevation obviously on the bottom. And I'll just highlight the portion there that's wider. So it's just that portion that's well behind the historic house. The addition adds 49 feet of depth onto the back of a historic house that's 51 feet deep. So it does not double. It's less than the depth of the historic house, which staff also finds to be appropriate. The materials are cement fiber siding, asphalt shingle roof, and masonry cladding on the foundation. Staff has would ask standard conditions to approve the masonry materials along with windows and doors. And I'll sum up. Staff recommends approval of the proposed addition to 927 Gilmore Avenue with the condition that masonry materials and window and door selections are approved by staff prior to purchase and installation. Meeting that condition, staff finds that this proposal meets the guidelines for the Waverly-Belmont Neighborhood Conservation Zoning Overlay.
Okay, any questions for Sean?
Sean, is the second floor of the existing house sort of, I mean, is it habitable? Or do you know if that's got
I did not provide it in the PowerPoint, but in the recommendations, it has, I think, a pair of bedrooms that sort of, think of it like the twin V, where they are cross-axis from the main axis, or across the main axis of the house. And it's changed a few times, but there might be like a Jack and Jill bathroom between. So yes, it is. Short answer, yes.
Did we feel like that transition down from that angle gives enough of the offset between the materials since it's coming in on an angle from the existing building to the new addition?
Yes, on the, well, okay, the top image there is the right side. There's an alcove that's set in, I think it sets in 2 feet and then goes back 3, and that has a different cladding. And it keeps the eave on the back of the existing house with a little alcove.
Can you go to the plan one more time and describe that, Ashley? So you're
Okay, so it sets in 1 and goes back 3, and that's the bottom edge there, the alcove.
The way, okay.
Go ahead. Oh, and then the top side, the left side of the house, it's similar. It doesn't look to be as pronounced of an alcove, but that's actually a little side porch with a railing that'll be there. You can see it on the bottom image. So it's fairly open in nature, and staff felt that was a sufficient distinction there as well.
Sean, the last one for me, it appears in the, unless I'm misreading the photographs, that the base of the stone base, is it painted? Or is that siding that goes to grade?
That is siding with a different reveal on the lower part, and if they're, Charlie, do you know the foundation of the house?
It's not painted.
Okay, and so that was my question, is I was misreading.
Sort of like a wainscot.
No, it's which
down to
does what you want it to do. I just wondered if we already had painted stone and there's an indication of stone on the addition, we typically wouldn't want them to paint that, but it certainly wouldn't be matched if it didn't get painted. That answers the question, though.
Sure.
All right, thanks, Sean. Anything else you got, or you good?
I'm good.
Okay, all right, thanks. Would the applicant like to come forward, state your name and address?
My name is Charlie Courts. I live at 927 Gilmore Avenue, and I've worked closely with Sean over the last few months as we develop these plans, and hopefully we're at a place that works with the guidelines, and I appreciate all of his efforts.
Okay. Any question for the applicant? Okay, thank you. Open public hearing. Would anyone like to speak regarding this project? Seeing none, close public hearing. Discussion or a motion?
Mr. Chairman, with respect to 927 Gilmore Avenue, move for approval with staff recommendations.
Okay, I have a motion and a second. Any discussion? All in favor?
Aye.
All opposed? Okay, motion carries. 1213 Linden Avenue.
It's the wrong way. It's still the wrong way. Am I going back or forward here? There we go. All right. So 1213 Linden Avenue is a circa 1920 home that contributes to the Bellsmont-Hillsborough Neighborhood Conservation Zoning Overlay. This top photo here dates from about 1968, and then those lower two are current. Note the existing addition off the rear in the lower left there. You can just barely see it. Here's the rear. You can see an existing addition there with the yellow siding, and here on the bottom you can see where it ties into the historic house. The proposal here is for a rear addition that's about 2 feet taller than the historic house. So I wanted to point this out to you. As you can see in the site plan, it looks as though this addition is going to wrap the side of the house, but actually if you look down at the first floor demo plan, they're removing the entire existing addition, so really it's all going to be a new rear addition behind the historic house, if that makes sense. So the new addition will be recessed where it ties into the original house on both sides. There's one window that's going to be enclosed on the ground level, the right side. Staff feels the removal to be appropriate as the window is not likely historic and it's minimally visible. Here are our side elevations. You can see that the addition is going to have a side gabled roof which parallels the existing roof, and there'll be a new ridge connecting the two. Due to the change in grade, the addition is going to be a full 2 stories tall. It's It's got a short little walkout basement area that's about 7 feet tall that's just going to be used for storage. And that second ridge you can see is about 2 feet taller than the existing historic roof ridge. Here is our roof plan. You can see the 2 parallel ridges and then the connector one. There is also a side dormer off the back of the original roof, which is set in 2 feet from the side as per the guidelines. Here you can see our front and rear elevations. Notice that from the front, the addition is going to appear somewhat like a ridge raise, although it will be recessed. And then note that on the back, there's going to be a deck. You can see those doors kind of to nowhere. There's no details in the plan, so staff does recommend that we are provided with those details before permitting. So in conclusion, we do recommend approval with the following conditions: that staff approve the design and materials of that proposed rear deck, that we approve the roofing material, windows, doors, and skylights, that any HVAC and other utilities be located on the rear facade or the non-street facing facade of the house. Any questions?
Any questions for staff? All right, thank you. Would the applicant like to come forward? Is the applicant here? Oh, there he is.
I'm still here. Michael Ward with Allard Ward Architects. Thanks, Jenny. It's pretty clear. If y'all have any questions, I'm here. Thank you.
Okay, thank you. Open public hearing. Would anyone like to speak regarding this project? Seeing none, close public hearing. Any discussion or motion?
Mr. Chairman, with respect to 1213 Linden Avenue, I move for approval with staff recommendations.
Okay, we have a motion and a second. Any discussion? All in favor? All opposed? Okay, motion carries. 110 Lindsley Park Drive.
Okay. So this application is for infill on a vacant lot in Laughlin Springs. The applicant is proposing a total of 3 infill homes on vacant lots. The commission reviewed these proposals in March and approved the first one at 106 Lindsley Park Drive. The applicant is back today with revisions for number 110 and number 114. So as a reminder, these building sites are vacant with double frontage on Lindsley Park Drive and South 15th Street. And the lots slope down significantly from Lindsley to 15th. The historic context on Lindsley Park Drive is 1 to 1.5 story homes with overall heights that range from 16 feet to 26 feet. We field measured them for you. The house in the top left here is 104 Lindsley Park Drive, which is infill that was approved 8 years ago in 2009. It's non-contributing. And the one on the bottom right is 105, which is contributing. So here we go. 110 has been significantly revised since you saw it in March. The design before you today is the one on the bottom right. The height has been reduced from about 30 feet to about 27 feet, while the primary eave height has been reduced from 20 feet at front grade to about 13 feet. The lot is slightly wider at the street than the other lots with historic homes. Therefore, we feel that the 34 feet proposed width would be appropriate, as opposed to 30 to 33 feet with the historic homes. This is the rear. As you can see, that has changed significantly as well. The overall height of the rear has been reduced. It was 41 feet. Bottom left shows our current proposal with a height of about 33 feet. Due to the slope of the site, that rear is a full 3 stories tall. The attached garage is accessed from a proposed drive off South 15th at the rear, which meets criteria for when attached garages are appropriate. Here's our site plan. The proposed infill will be oriented towards Lindsley Park Drive. It meets all zoning setbacks. The front setback will be consistent with the infill at 104 and the proposed infill at 106, which you have approved. This is appropriate since there are no historic homes on this side of Lindsley Park Drive. And here are our side elevations. This red arrow here points to a significant section of blank wall. It's about 23 feet there. Staff recommends that a window be added in that area. For context, here's a photo of the rear of that existing 2-story infill that is at 104. And in conclusion, we find that the proposed massing and overall height of the infill at 110 Lindsay Park Drive is compatible with the scale of the immediate historic context, which includes 101 half-story homes. And we recommend approval with the following conditions: with that window to be added on the north elevation first level, the finished first floor height to be consistent with the historic context. Staff will approve the windows, doors, garage doors, porch railings, porch posts, driveway materials, masonry, and walkway material. The HVAC will be located towards the back of the house. And then a new condition that is not in your packet there, we'd like the 5-foot grade change from the street to the front of the house to be verified. And you all should have also received an email from Councilman Withers in support. And do we want to do these separately, I'm assuming? So that's this one.
You know, just one real point of clarification for others too. Should we go by the staff recommendations that we are shown here, as opposed to what we're shown on our report, right? Okay. All right. Thank you. Oh, any questions for?
I'll clarify that you shouldn't follow this one or that one. You should create a motion that you feel meets the guidelines, which could be either one or something else entirely.
I disagree, but you know, it's kind of like, well, this is because on this one it said that a new north elevation site plan be submitted in there, which I agree with this one, but I just want to make sure I understand. That's understandable.
I think probably this has typically been done, but as a request, that there's flashing lights that say new condition or that something has changed from.
That's a good idea.
I don't pay that much attention sometimes, so that certainly is appreciated.
New condition in big bold letters.
That's right. When possible, that's very helpful.
Yeah.
Okay.
Yeah, I thought that helped out a lot. The one question I have, though, is that, you know, when the 5-foot grade change be verified, if it's 4 feet or if it's 6 feet, then what does that do to the approval that we've given here?
I would add that should, or I'm sorry, it does say 5 feet, and that was a condition of the last project, was that the belief that is the grade is 5 feet below the street, and so the condition was that it should be, and if it's not, then it either comes back to you, or they need to dig into the grade to get it at 5 feet, but that's my understanding of the last condition, but of course this could be something else completely.
And so I'm still confused on that. The last condition has to do with the perceived total height of the proposal?
Correct.
And that would potentially change if the house sits up taller with respect to the street.
Because of the slope of the site, across the street there are historic homes that are potentially as high as 10 feet taller than where this home will begin because of the grade. So although the tallest historic house is, I believe, 26 feet, this one's proposed at 28, but it's going to start 10 feet lower. And we just want to verify that there is indeed that drop from the road.
And the street's level, it slopes?
The street itself?
Yeah.
I believe it's, let's see, I believe the street itself.
It's a big slope.
Let's look.
It's across the street.
Yeah, that's not a very good picture.
I think it wouldn't be hard to be in violation depending on where you measure this from. So I think I understand what the condition is. So yeah.
Okay.
Yeah, maybe.
I think that condition was more important when the house was taller.
The other one.
And because there was objection to the other houses, the historic homes being shorter. And so that was, not the height of this has been reduced fairly significantly. It's probably not quite as critical as it was before, but you're right, with the slope of the street, it'd be hard to verify that.
I'll make one comment on it. This came from the March meeting where 106 Lindsley Park was approved, and I think that lot even has a more significant slope, and John will know better, but than these, like 5 may be more than is necessary here, because I don't think the intent is to make them dig it out. That wouldn't seem right. The idea was they were going to be taller than the historic. Like if you look at the picture up here, looking up the hill, directly across there, a lot of them are one-story, true one-story homes. So the idea was like, you're going to build this modern, larger home, but as long as it sits below the street, because taking advantage of this grade, it's going to balance out. The idea is to make sure that the finished floor isn't sitting level with the street so that it towers over everything, as long as it sits down in the hill, because the setback would be 20 feet, I think. And by the time you get 20 feet down the hill, you have picked up quite a bit of slope. We can get to it later, but I wonder if the measurement, it would make sense to clarify that it should just be from the middle of the lot, since that road does slope, just so there's no argument about that.
Well, why don't we bring applicant out, and we can, if we need to talk through it a little bit more, but if you'll come up, John, and state your name and address.
John Root, 753 Alloway Street. And you're right, I mean, I'm just going off the topo, the surveyor's topo, and we can put it in Fred's capable hands of kind of dealing with finished floor elevations out there and where we need to set them. Obviously, we're going to be below the street, and I think that was the intention of marking some of the grade elevations on the porch in the submittal, just to make sure that those porches are, you know, no more than 3 courses at grade wherever that front setback point is. So, thank you.
Any questions for John? Okay, thanks. Open public hearing. Anyone like to speak regarding this project? Okay, close public hearing. Discussion? Motion?
I think it's a tremendous improvement over the March submission, and really with that condition, to clarify that it'll be set down the hill and below the road. My only comment is the rear elevation. Because 15th is a real street and not an alley, it's already a huge challenge for these to look like they're not they're going to tower over 15th regardless, and that is what it is. But I wonder if the double-decker porch creates this long line rather than stepping back. The other 106 step back, 114, we'll see steps back. I wonder if this one should too. I'm not sure it's a huge deal, but curious what other people think. Personally, I think stepping back as you go up the hill in the rear elevation helps with the condition that they can do nothing about, but it does help to mitigate it some.
Stepping back differently than what he's got shown?
Yeah, let's see, where's the...
It does show that you're 50 feet back from that right-of-way, not necessarily from the street, but 50 feet.
It's one long line of probably 30-some feet in the rear. If you stepped back on the second level of the house, not have that deck there, I think it follows the hill as you go.
You're saying just stepping that second deck on the top, back in.
I'm assuming they wouldn't want to take away that square footage. I guess what I'm saying is whether the second level deck should be eliminated so that as you go up the hill in the rear, the building steps back. That's what we did on 106, I believe. And we'll see in 114 they do that. I think it helps with what it's going to look like from 15 to not have this towering straight line coming up. A deck is certainly better than the full massing of the house.
Any more discussion on that?
I guess I understand that. I would say stepping in a little, but I mean, I know the importance of that deck and just comes to the view that you have back the other way.
If you guys will allow me a little latitude, do you understand, John, do you mind coming back? Do you understand that? Maybe state your name real quick. But
Sure, John Root. Yeah, we initially didn't have a roof over that second floor porch, and the client came back to us and said we really would like to have that out of the rain. to get that stair stepping, we could expand the garage out a little more and the lower porch out a little more, maybe 5 feet, to kind of create that stair stepping, if you think that's a good compromise. Is that kind of what you're looking for? Is kind of that?
I think the stair stepping helps. I don't feel strongly enough about it that it should make more massing. Yeah, I think it looks better from the street than the stair steps, but if the trade-off is more extension and massing, that's probably not a good trade-off.
Okay, thanks, John. All right, do you want to craft the motion then, Aaron?
I do have one other thing, too. I'm a little concerned, looking at there's a topo with the front porch shown and the street shown and all that. And I think the 5-foot, and you may not, yeah, there you go. So I think that there, with the porch shown at 495, 500 feet is the line that crosses sort of toward the bottom of that site on the right-hand side. And I'm just concerned that if we insist on that 5 feet, we may wind up with a situation where water comes in the front door. It's pushing it quite a bit. I think clearly the intent here is to have it lower than the street, but whether 5 feet's the right number or whether the staff should have latitude to ensure that the intent of this is met versus the specific number of 5 feet is a question.
We're talking about extending the house 5 feet to the rear and turning the 30-foot?
Actually, I was back on the front of the house with that new condition of it being 5 feet lower than the street. And
the question is, if you go from the road to the front of the house, if you're dropping 5 feet in 20-ish feet, are you going to be able to deal with drainage? I mean, you've got some area on each side.
I've spoke with the contractor about this, and I think there'll probably have to be some sort of retaining wall feature to try to get stormwater dealt with there. Is that kind of what you mean? Yeah. I think we're going to have to work with the stormwater and maybe a civil engineer to kind of figure out what to do there. But I think, generally speaking, to set we're just going to have a little bit of flexibility with Fred to figure out where this first floor really needs to end up, and that's all going to be staked out, and so everybody can see it. And so, yeah, we commonly do this on a lot of our jobs, and have a better set of eyes. We'll get staff out there to look at it if we need to. We're fine with that.
I don't want to run roughshod over the staff's condition, but if I heard the presentation correctly, this house is measured 27.6 from grade. Practically, there's going to have to be some flat or hopefully even sloped away from the house grade at the front. John's not going to want that kind of liability running back on him a couple of years from now when somebody's got a swimming pool in the crawl space. So if we're not overly manipulating the front grade and causing excessive cost of retaining the road and the earth underneath it, I'm struggling with, are we just mashing this whole thing down? I'm not advocating that it goes in the other direction where you mound it up and it gets taller in its appearance, but it's already going to be from the center line of the street down considerably, and it's equivalent to homes that are across the street. I just wonder what I'm missing in the hard 5-foot requirement.
Yeah, hard and fast rule.
And I think we could change that condition to approximately 5 feet so that it gives the staff leeway to interpret that.
And I think that's a good idea.
Yeah, and that 5-foot number came from me and dealing with the topo map. And I think that was a comment in the last hearing, was that generally speaking, all the floor levels are 5 foot lower than the middle of the road. And that was in the context of talking about the overall height from grade. Just keep in mind that minus 5 feet, that's really, standing in the road, that's what you're going to perceive as what the height really is. So.
Did you have anything you want to add, Robin, to that? Or okay. All right, are we clear? All right, thanks again, John. Okay. Let's try to craft a motion to that, I think.
So I'll move approval of the application at, let me get back up to the top here. 110 Lindsley Park Drive with staff recommendations, with clarification on the new condition that the staff, in their field verification and in working with the applicant contractor, that the finish or the top of foundation wall and finished floor be coordinated to provide reasonable accommodation for water to slope away from the front of the house, and that, the earth not be mounded up to increase the perceived height of the house, but that there not necessarily be a hard number of grade change, that it would generally correspond to the natural grade of the existing lot.
Okay. We have a motion. Do we have a second?
Second.
Okay. Any discussion? All in favor?
Aye.
All opposed? Okay. Similar case, 114 Lindsley Park Drive.
Okay, so next door, we have 114 Lindsley Park Drive, also infill, same double frontage, steeply sloped lot in historic context. Here's 107 across the street. This is actually the tallest contributing house on the block, and it measures about 26 feet above grade. And again, it's up that hill, whereas we are building down. Okay, so like number 110, the proposed infill will be oriented towards Lindsley Park Drive. It meets all the base zoning setback requirements. The subject property is highlighted here. The gray one is number 110 that you just approved. The front setback will be consistent with the infill at 104 and the proposed properties at 106 and 110. Here's our side-by-side from March and what you're looking at today. Let's see. The infill, again, is 1.5 stories at the front with an overall height of approximately 28 feet. The immediate historic context has these 16 feet to 26 feet homes. Staff feels the overall massing is mitigated by the projecting front bay with the low eave height, the wraparound porch, the breakup of the roof massing into smaller components, and the fact that the house sits lower on the street, as we just discussed. Given these factors, staff feels the 28-foot height is compatible with the context. Again, we have a width of 34 feet. However, on this one, the width at the front setback includes a 16-foot porch, which will help mitigate the width of the building. We feel that that is appropriate as well. Here are your side elevations. As you can see, this one does step back down the hill. The tallest point of the house is 40 feet from grade at the rear, but this portion of the house is set back 26 feet beyond the garage facade. And here we are at the rear. You have your March versus your current proposal. The massing steps down, as we said, so it's only 1 story there at the back at the garage. The height of that single story has been reduced from 15 feet in March to 11 feet today. As with number 110, the attached garage is accessed from a proposed driveway off 15th Street. This meets the criteria for when garages are appropriate. In conclusion, we find that the proposed massing and overall height are compatible with the scale of the immediate historic context and recommend approval with the following conditions. The finished floor height will be consistent with historic context. Staff will approve the windows, doors, garage doors, porch railings, porch posts, driveway materials, masonry, and walkway material. The HVAC will be located behind the house or on either side beyond the midpoint. And a new condition that you may choose to alter, that the 5-foot grade change from the street be verified.
Okay. Any questions for staff? Okay, thank you. John, you want to say anything else? Okay. Open public hearing. Anyone else want to speak about this? Not seeing none, close public hearing. Wish we could repeat back Ben's, so I don't know if you can remember that exactly. You got it? So whoever's going to make the motion, Robin's got Ben's part for that, so you don't have to redo it. And if you want to do it, Ben, and recognize that, you're more than welcome to.
I just have one question. Overall, I think it looks good. This setback on the site plan, this is kind of, the setbacks are tricky here because the road curves, and so the 20-foot is based off of nearest corner. In the site plan, it looks like it's at 20, and staff's recommendation is at 23. All the others were 20. I assume it's 20, or is it 23? Or, I mean, it's kind of tricky because there's a curve, so.
Yeah, it's 20 foot off the pinch point there, so on this one, it would be 20 foot on the far left of the house, if you're looking at the house on the far right of the house.
Yeah, that all sounds good.
Just for the record, John, go ahead and, since you had to come up, say John Root and your address again.
Oh, John Root, sorry, 753 Alloway Street. Yes, all of these, all the pinch points are on the left-hand side of the house, the northeast corner of the houses.
Before you sit down, is there anything else that we might have for John regarding this one? Okay, thanks.
Thank you.
Mr. Chairman, with respect to 114 Lindsay Park Drive, I move for approval with staff recommendations and with the bin language for the special condition.
Okay. Okay. We have a motion. We have a second. Any discussion? All in favor? All opposed? Okay, motion carries. 1111 Lillian Street.
1111 Lillian Street is a vacant lot. A non-contributing structure stood there previously, and it's been demolished in the last few months. And the applicant is proposing today to construct a new 1 1/2 story dwelling on the lot. All right, there's a site plan. So it's the footprint to the left, on the left side, is 1111. The 3-foot structure footprints to the right are also recently constructed infill projects over the last 2 or 3 years. The house at 1111 will be 30 feet tall, 32 feet wide, a scale that's very similar to the 3 recently constructed houses to the right. The character of the building will be very similar as well, with similar roof shape and pitch. And materials, including cement fiber siding, asphalt shingle roof, split face concrete block foundation. The new house will have attached covered parking at the rear, accessed from a side driveway. And given the size and slope of this lot and the lack of alley access, staff has found this configuration or similar configuration appropriate on the 3 other structures and finds it appropriate on this one as well. There's the left side. The rear. That's the vacant lot, and the 3 recently finished in the last year or 2 houses to the right. Staff, I guess that's the new one in a more direct view in relation to its new neighbors. Staff recommends approval of the application to construct a 1 1/2 story house with attached parking, with the conditions that the floor height is consistent with the adjacent houses to be verified during construction, that the roof color and final selections of windows and doors are administratively approved, and that the location of HVAC is administratively approved to be on the rear or behind the midpoint of a side-facing facade. Meeting those conditions, staff finds that the proposal meets the guidelines for Lachlan Springs overlay.
Okay, thanks. Any questions for Sean? All right. The applicant has notified that they are comfortable with the recommendation. Open public hearing. Would anyone like to speak regarding this project? Okay. Close public hearing. Any discussion or motion?
Move approval on 1111 Lillian with staff's recommendation.
Second.
We have a motion. We have a second. Did you say second?
Yes.
Okay. We have a motion, second, discussion. All in favor? Aye. All opposed? Okay, motion carries. 1914 Tanglewood Drive.
Okay, 4914 Tanglewood Drive is located within the Tanglewood Historic Preservation Zoning Overlay, a collection of log homes nestled in a wooded area near Inglewood, just north of the Briley. The lot is currently vacant. The house that was formerly in lot, which you can see in the picture on the left, burned to the ground earlier this year. That house was not one of the log homes. That's the predominant character of the neighborhood, the house that burned. The National Register called it a non-contributing structure. But it's no longer there because unfortunately it burned. And so you can see the lot, the vacant lot right now on the right. So here is the general site plan for the new infill proposed for the site. Generally speaking, the house will be in about the same location as a former house on the lot. Here is the front facade. The proposed infill will be largely 1.5 stories with a 2-story bay at the front and on the rear. The bulk of the house will be 20 feet tall, which matches the height of the previous house on the lot. The 2-story bay will be 22 feet, which staff finds to be appropriate. You can see in the photo that the former house on the lot did have was mainly 1.5 stories with a 2-story element. Here are the side facades. The house is proposed to have 10-inch lap siding, and I know we had a very extensive conversation earlier today about lap siding reveal. Staff does find that 10-inch lap siding is appropriate in this location for several reasons. First of all, the predominant character of this district is log homes, and logs are obviously, pretty thick. There really aren't any siding homes in this area that are in this district that's contributing. It's a fairly cohesive historic district. Also, it's just outside the Inglewood district, and the Inglewood district does allow for the up to 10-inch siding reveal. The former house, the house that was formerly on the lot, also had the 10-inch reveal. So for all of those reasons, we feel that 10 inches is appropriate for this house. And there really just isn't any narrow siding in that district, so there's not really anything to compare it to. So in conclusion, staff recommends approval with our common conditions, including that staff will want to approve the finished floor height, the windows and doors, the roof color, the approval of the driveway and parking area, the HVAC location, and because this is a preservation overlay, not a conservation overlay, we will want to approve all permanent landscape features like fences, pathways, anything else you can think of that's a permanent landscape feature. So with that, just conclude that we recommend approval, and the applicant is here.
Any questions from Melissa?
Are there other 2-story structures in this preservation district?
Most of them are 1 to 1.5. I can't recall. Robin, do you recall if there's any that are 2-story?
The grade here changes dramatically. So I think there are portions of existing buildings that get to 2 stories.
I see. Okay.
Depending on where the grade.
All right, thank you. Would the applicant like to come forward? State your name and address.
Hi,
Is that
Cheyenne
Kelsey
Smith,
leaving?
1627.
Is that Kelsey leaving?
Yes.
Okay, Kelsey. Oh, well. Kelsey, we just recognize you as an intern, so sorry you have to leave. Okay. I apologize for interrupting you. Would you mind restating your name and address?
Sure. Cheyenne Smith, 1627 Long Avenue, and I'm in agreement with the staff's recommendation.
Any questions for the applicant before you? Okay, thank you. Open public hearing. Anyone like to speak regarding this project? Seeing none, close public hearing. Any discussion or motion?
Mr. Chairman, with respect to 4914 Tanglewood Drive, I move approval with staff recommendations.
Okay, we have a motion and a second. Any discussion? All in favor?
Aye.
All opposed? Motion carries. 1805 Sweetbriar Avenue.
(1805) Sweetbriar is a 1-story brick house constructed between 1947 and 1951. Staff finds that this house does not contribute to the historic character of the Belmont-Hillsborough Conservation Overlay. Although this particular block of Sweetbriar developed later than other blocks on Sweetbriar to the east, in other parts of the Belmont-Hillsborough neighborhood, the building in 1805 Sweetbriar has been significantly altered over the years with the addition of those 2 front bays with the triple windows. Those are not part of the original house. So because of the changes made to the house, staff finds that it is not contributing and recommends the approval of its demolition. So the application before you is to approve infill and a detached accessory dwelling unit. Here's the site plan. The detached accessory dwelling unit does require a rear setback determination. There is There really is no alley. It shows on the site plan that there's an unimproved alley, but when you look at the aerial, it's just all grass. So the garage will be accessed via the front driveway. They're proposing to locate the dadu 3 feet from the rear property line. The dadu is more than 700 square feet, and when an outbuilding is more than 700 square feet, codes says that the base zoning should be 20 feet from the rear property line. It's pretty standard for the commission to reduce that 20-foot rear setback to anywhere from 3 to 10 feet. So we are recommending approval of the setback determination of 3 feet from the rear for the dadu. So just a little bit about the context. So again, this block of Sweetbriar developed later than other blocks of Sweetbriar, particularly those blocks further east. You see a lot of 1940s, 30s, 40s houses that are, minimal traditional or kind of colonial revival-esque, I guess. So here's just some images of immediate context photos. And then next door to this site at 1809 Sweetbriar, the MHCC approved a 27-foot tall house. And then across the street, that same year, the commission approved 1808 Sweetbriar, which is 31 feet tall. Because the existing context is more houses that are between like 20 and 24 feet tall, but the commission did approve a 27-foot tall house next door to this site, so therefore staff thought that when we were talking with the applicant that 27 feet would be the maximum height for new infill. So that's what they're proposing. Here's the front facade. Again, it'll be 27 feet from grade. At the front entryway, the applicant here is showing a triangular window opening, which staff found did not meet the design guidelines. The applicant actually this morning sent me revised drawings addressing that issue. I have not had a chance to look at them, but the applicant is working with us on revising that window and also on including a trim board at the base of the dormers, which aren't shown on the drawings, but I believe they will be adding that back in revisions. Here are the side facades. I don't think we have any changes requested for the side elevations. And here are the drawings for the detached accessory dwelling unit. Staff finds that its height, scale, materials, form, et cetera, meet the design guidelines and the DADU ordinance. So in conclusion, we recommend approval with the following conditions: that the finished floor height be consistent with the immediate context, that we approve the windows and doors, shingle color, a brick sample, stone sample, the material for the driveway, that trim boards be added to the bottom of the dormers, that the applicant work with us on the window opening above the front entryway, that the HVAC be located behind the house or on the side, and finally that the applicant submit a copy of the recorded restrictive covenant for the DADU. With those conditions, we recommend approval, and the applicant is here.
Okay, any questions from Melissa?
This is a parking sort of front drive item.
Yep.
I know in other districts, a lot of times because there's no alley, there, driveways are present and so forth. And I noticed in some of the photographs, we've got some very residential circular front parking, drive, party, whatever, which is
I don't know the history of this one.
not desirable, but
I don't know the history of this one. When there's an existing house in a conservation overlay and that's all, they're just putting in driveway, we wouldn't review that or regulate it. We would for infill. My understanding with this one at the top, they actually put it in after they closed out the permit. So we did not want to see that there, but it kind of fell through the cracks of the gray area where it was done outside of our purview.
just like to clarify that the application does not show a circular drive at the front and that reiterate that parking in front of residences is discouraged.
I believe there's an existing driveway there now that they will be using.
Okay, thanks, Melissa. Would the applicant like to come forward and say anything about the case? State your name and address.
Yeah, just real quick. My name's Andrew Scott with August Development. Thanks, Melissa. First time going through this process, so it's been unique and interesting. Learned a lot. But anyway, we'll make the recommended changes and we'll move forward. So thank you.
Any questions for the applicant before he sits down? Okay, thank you. Open public hearing. Seeing none, closed public hearing. Motion or discussion?
Move approval with staff recommendation 1805 Sweetbriar.
Okay, we have a motion and a second. Any discussion? All in favor? All opposed? Okay, motion carries. I think all the other business has been moved off, right, Robin, looks like?
That's correct.
Okay. When was that workshop? Let's talk real quick about the next sliding workshop. You had a date for that?
Yes, we're shooting for June 19th from 4 p.m. to 6 p.m. It would be in this building, in either this room or the one right next to it that's all kind of one big room. It is a workshop to talk about building and signage illumination. We are working on having maybe 4 presenters provide just brief background information to facilitate the discussion, and then the majority of the time will be a guided discussion and then just free comments about anything anybody wants to say about the issue.
And that's a public hearing?
Yes, and this is primarily Broadway Historic District that this would affect, this discussion will affect, but it could also affect Second Avenue and the downtown historic districts. It's not likely, it will not affect any of the neighborhood conservation zoning overlays because we don't review either building illumination or signage in the conservation zoning overlays.
Okay. I did want to reiterate the point that Ben brought up. I do like the recommendations on there, but I would think it might be good to highlight the differences because we typically don't read all of them again, and we want to make sure that we're what conditions we're approving. So that'll be good. And then last, and very not least, but sad, is that this is Macy's last meeting, right? Yeah.
I think so.
Yeah. So.
I don't think I'll still be here for the next one.
Yeah,
It's
so-
possible, just depending on the transition, but
Well, just in case, we want to say we're sorry to see you leave, but
I'll still be at Metro, so I'll still be around, just with a different.
but not around with us. So that's all we care about. But we've enjoyed working with you. You've become a staple to here. So, yeah. So thank you. Good luck with your next endeavor.
Thank you.
And with that, we are adjourned.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.